own actions.
That's the issue you raised, that
That's the
they had
issue-
started from around November the previous year.
When I went on leave, in December 2014.
I indicated to him in my position that I had no powers to tell people to cancel tenders and that I had not given any such advice. Now, obviously, on your version, that couldn't have happened because you didn't allege that he had cancelled any tenders, or did you tell him that?
No, Chair, I didn't speak about a specific tender. You'd recall earlier on, I mentioned a number of these tenders that were, not tenders, but contracts, existing contracts that were either being stopped or investigated, and that's what I discussed with him.
Okay, I think let's put it this way. Here, he suggests that you cited as an example that he had told PRASA employees to cancel some tender. Would that sentence be correct if we change tender to tenders?
No, Chair, these were existing contracts.
Contracts, yeah.
Yes, not new tenders that
Yes,
would be issued
yes.
here.
But if he said contracts there, would that sentence be correct then?
Yeah, Chair, I told him about the number of, I mentioned the
Yes.
number of contracts.
Because he says you said, as an example, that he had told PRASA employees to cancel some tender. You are saying one, you didn't talk about a tender. You talked about not one contract, but a number of contracts.
Existing contracts.
Existing contracts. And your version is that you raised the issue that in respect of a number of existing contracts, he had said they should be cancelled. Is that what your version? What you said to him on that occasion?
Exactly, Chair. The issue about, and that's why the point we were discussing before lunch.
Yes.
The issue about there's a general feeling.
Yes.
Remember the general feeling?
Acceptance.
And you asked, Chair, correctly.
Yes.
Who's the general?
Yes.
Precisely because that was the issue, Chair.
Yes.
And I said, you firstly didn't have the authority to do so.
Yes.
But also you are applying it in a very selective way.
Yes.
You see, Chair, let me provide one factual issue here.
Yeah.
What had happened at that time, and this, other than what I mentioned about the Cape Town meeting with the chair, subsequent to that, there was an email, which I don't have, but I think some of the information presented here, be very
Comes
selective,
from it.
Chair. Mr. Lindikaya, who was a company secretary at that time, had then sent a list of contracts, of existing contracts, to Mr. Joseph Pungula, who was the chief procurement officer at the time. And these were contracts that they wanted to investigate. And that list, of course, that email came to my position and was consistent with what we discussed with the chair in Cape Town. So that's when I decided that I will act. So this thing about some contracts being invalid or void, it's not an isolated thing. It was part of a thing that certain contracts, not contracts, and Chair, I give, by the way, in my affidavit, examples of, for example, contracts almost similar to Prodigy, but they will not even be investigated or looked at. So they selected because what they were looking for, again, I deal with it in my affidavit, they thought that there are some powerful forces lurking behind these tenders. And they found that that's not true. It's ordinary people who were doing work, and they just went on to destroy their lives.
So, would it be correct to say you did accuse him on the occasion of telling PRASA employees to cancel certain existing contracts?
Yes, Chair. They either, the biggest thing that was happening, Chair, they would then block payments,
Yes.
and say it's under
In the finance
investigation
department.
and all of those things in the Chair.
Yeah, okay, all right. I hope that helped Mr. Sobi to clarify.
No, it certainly does.
And Chair is consistent with the letter, with rather the email that council read earlier on, my own email
Yes, yeah,
to,
yeah.
to all the three people to
About
say
the campaign.
about the campaign that was happening. Chair.
Yeah,
And this is
okay.
what destroyed PRASA today.
Okay. Mr. Sonny?
Mr. Montana, you said that there was an email that Mr. Lindikaya had sent, which had a list of contracts. Do you have that email?
No, I don't have, Chair. But at that time, I did have, I could no longer access, after I've left, I could no longer access my email, Chair.
Can I ask you this? On that, I mean, there must be contracts that were on that, listed in that email that you will remember. Was Prodigy one of those contracts?
Chair, I think Prodigy was one of them, yeah.
You think, or was it?
No, it was.
The Fambo?
No, Sefambo was on that list, Chair.
Siangena?
Siangena was on that list. Mashonisa was also on that list.
Oh, there was one called Mashonisa.
Well, the name Chair is still running away from me. But in the course of our conversation,
Okay.
I put it on record, Chair.
Okay, all right.
Any other that you can remember?
Chair, there was there was one dealing with the introduction of a security system on the central line in the Cape. I think that was done by one Israeli company, which was putting new technology to protect the network there. So we did a test of that. I think that there was the issue of a company called Sofinity, if I remember well. There was quite a couple of companies, Chair, that were on the list of that email, where these companies, they needed information to look at.
And Royal Security?
Royal, Chair, wasn't there. Royal wasn't there.
Strawberry Walks?
Strawberry Works was there.
So just to make clear what your concern was with regard to what you say Mr. Dingiswayo was doing or he and others were doing. With regard to Mr. Dingiswayo, your objection was that on your understanding, he was making decisions that he had no authority to make in the company in terms of instructing people to cancel contracts, or is the position that, on your understanding, he was giving advice as opposed to giving instruction to certain people in the company to cancel contracts in circumstances where that advice should go through certain channels and it wasn't going through certain channels? I just want to identify what it is that you found unacceptable in terms of what he was doing.
No, Chair, I've already formed a view at that time, a firm view, that here's a chap who's not working in the interest of the company, who's pursuing a particular agenda. And for example, finance will say, we are not, when a company writes to me and say, we are not being paid, or there's this problem, then finance will say, but this contract has been flagged by legal for investigation. I said, but what is this investigation happening? Who has authorized such an investigation? So Chair, so that view I formed. And when I called him to say, hey, I think your time is up here, that was the matter. The other issue was the fact about when he says, I will not draft the agreement. There was the issue about his ex-boss who had left and refused to represent the interest of the company. I said, all of those combined have given me a clear view that you are working with other people to undermine PRASA, to create this thing of this massive, what is it called, grand corruption in this company, when there's none. Yeah? And Chair, that is why I said earlier on that his right to identify shortcomings, weaknesses, or even irregularity Chair, is proper. But when you do that and you select, you target the company that is owned by Zondo, and you jump the one that is owned by Montana for the same thing with the same company. In my, Chair, for example, in my submission on this specific issue, I list the companies that were in the same position as Prodigy. Mr. Dingiswayo jumped them. And even fast forward at the time when I'd left, between that time I'd left and his testimony to this commission, there were a lot of companies, Chair, that Mr. Dingiswayo didn't even raise a hand and say, Worksman was appointed irregularly. Why? Because it's Chair, it's the same WhatsApp group. That high, Chair, those are the words you use. Let me give you another one. There's a company called Forefront, okay, which Mr. Molif and his board handpicked for the work that they needed to do in terms of media and all of those things. These were raised by, not by me, they were raised by even National Treasury, as it were. Mr. Dingiswayo, between the time I left, if indeed he was this champion to fight against irregularity or any form of corruption, why then do you jump those? Why do you select? And that's the point that I'm making. And I realize that he's not working for this company. He's working for certain people in the company. And I said to him that, look, the usual route is a disciplinary route. But for someone like you, you and Martha, in fact, you have made it very clear. You've what is the word? You have confirmed where you stand on these issues. And I said, you can't work for me. You can't be. How do I sit with it? Because you remember, Chair, even though Fanny reported to Martha, the appointment and dismissal of GMs was the CEO's responsibility. So I took that decision. In that meeting, I decided to fire him, and after I've explained to him, I said, you're not going to explain anything. I think you're not working in the best interest of the company, and I formed a firm view around that.
Let me try and summarize what you are saying as I understand it for you to say that's a fair summary or not. You are saying prior to this meeting that you had with Mr. Dingiswayo, you had come to the view that there was a campaign that was being waged by certain people against you. And you have named them. I think there were 5 when you added, and Mr. Dingiswayo was one of them.
Indeed.
And when you called him to this meeting, this particular evening, you had a discussion with him and you decided to fire him. And you told him so.
That's correct.
The reason why you fired him is that you had concluded that he was working against the interests of PRASA.
Did you?
And you say that was evidenced by his participation in this campaign.
Indeed.
And you say that he was in this campaign was also, the conclusion that he was part of this campaign was also shown by the fact that he or they were selective in terms of the contracts which they said should be cancelled or should be investigated. There were other contracts which may have had similar problems, which they were not investigating. That's why you dismissed. Okay.
Chair, let me add, I think you've summarized it correctly.
Yeah.
I need to say, Chair, that one of the things is that he has not given me the opportunity as a person who should make the decision on this matter. I've never received a single memo
Yes.
or message from Mr. Denis
Yes.
saying that, and that is why my email that I've sent, before I fired him, so there was an email.
Yeah, that email.
There was the conversations that were taking place. And I did tell the chair of the board, Mr. Molefe,
Yes.
these people that are briefing you and providing with information, they're going to mislead you. And today we are paying the price, Chair, with the PRASA that has collapsed.
Okay, all right. Thank you. Mr. Sonny?
As you please. Mr. Montana, let me ask you this, because the impression that I get reading Mr. Dingazwayo's affidavit is the reason you called Mr. Dingazwayo on the 19th at 7 in the evening is to inform him that you had decided.
Indeed, Chair.
So you had made up your mind before the meeting, and the purpose of the meeting was to communicate.
No, I've made up my mind, Chair.
And,
I've made up my mind. That's correct.
and the purpose of the meeting was to tell him that you are dismissed.
That is correct, Chair.
Well, you said something about, you said the normal process would be a disciplinary inquiry.
Indeed, Chair.
And you said to him, but for people like you, as I recall your evidence, in effect, it's not even necessary to go that route. You are fired, is my
Chair, I've
understanding.
taken a decision that Fanny should go.
Yeah,
I've made that decision, and
Yeah.
and yes, the normal process, if it was a borderline issue,
Yeah.
of facts had to be established. But I was convinced that here's a group of people working inside the company who are actually not even prepared to even follow the direction that we've agreed upon. Because what PRASA was implementing were not Montana's decisions. Were decisions that were made by our executive committee, and there were decisions made by our EXCO.
Mr. Sonny?
Montana, let me ask you, when had you firmly decided that you are going to fire Mr.
Now, Chair, if you read that email, you can see that you remember, Mr. Soni, when you read that email, I emphasized that it gives you exactly
Your state of
Your
mind.
thinking
my
at
state
the
of
time,
mind.
yeah.
It captured.
Yeah,
I can't deny it, Chair.
Yes.
Yeah.
Yeah.
And the reason I ask is, you don't say that in that email. I gather that that was on your mind when you wrote that email, because you recall I asked you, you confirmed that the email was sent at 3:14 p.m., you remember?
Yeah.
This is on the 18th.
Yeah.
And now we're looking at 27 hours later, when you meet Mr. Dingazwayo, say you are dismissed. The question I want to ask you is, at the time you wrote the email, had you decided that you were going to dismiss?
No, Chair, I've made up my mind. I think that you can see that one of the sentences that I put
Yes.
there is very clear. My mind was very clear.
Yeah.
That there are certain people that it's
Should
either I
go.
go or they go. But we're no longer going to find any common ground. And that was the case, Chair.
Okay. So at the time you wrote this email on the 18th, you had already made up your mind.
I've made up my mind, Chair.
Well, let me ask you the question. Did the disciplinary procedures of PRASA allow you to make that kind of decision before there could be a disciplinary hearing and the affected employee could be heard?
Chair, the disciplinary code, and I think that together with with some parts of the Labor Relations Act,
Labor Relations Act, yeah.
I think that is generally the principle that you must subject to someone, give him a hearing, subject him to the disciplinary thing. That is the overall principle, but I don't think it excludes in some instances, the issue of summarily dismissing someone when you think a lot is at stake. And I think that when you drive a wedge between board and management, it's a serious issue, Chair. And it's something that, in my view, and it's a choice that you make as a CEO. It's ultimately we are CEOs because we have to evaluate all the evidence and make a decision. My decision was that the relationship between, and we saw how you asked the question, I think it was you, Councillor, who asked the question, why the relationship between myself and Mr. Molefe even deteriorated, Chair. Other than the process of his appointment, there was a lot of these things happening. When Mr. Molefe asked me those issues raised those issues in Cape Town, it was quite clear, Chair, that there was a lot at play. That I go on leave, people feed the chairman with all of those things. He didn't get them from me. He got them from someone else. And I knew, Chair, when I came out of that I'm going to deal with it firmly and decisively.
Okay. Mr. Sonia?
As you please. Mr. Montana, I do not want us to debate. I'm just going to present this and you must comment.
Yeah, and I wanted to say, of course, we accept that we are not CCMA. We're not the Labour Court. We're not here to assess the fairness or otherwise of the dismissal. But I just wanted to get that information.
There are two rules of natural justice. The one rule is hear the other side, or the other consultant. And the other rule is you should not be a judge in your own cause. Nemo judex in re sua. Now, I'm not trying to sound clever, but in this case, you broke both the rules. You didn't give him a hearing, and you yourself took the decision.
Chair, look, I think, Chair, we had processes at that time. I think that in most instances, it is assumed that when we say we gave you a chance, we mean a disciplinary case. The consultation is part of that process, Chair. And I think that that's what would have happened. And secondly, Chair, these matters are not about me. Maybe we are relating it to, but they're about PRASA. That's about if you come in and block the implementation of contracts. It's about PRASA. It's not about me. I may be the CEO, and the board asked me about the performance. I've got to act against that. So we did, of course, Chair, deal with that issue. There was a meeting between myself and the Chair, because a day after, the same thing happened with Mathangoy. I think we'll deal with it at a later stage. But the same process, because Martha then came to fight about the issue, and I said, here's the issue, and you are part of it. Okay? But at the next board meeting, I think they went and raised it with the chairman of the board. We had a board meeting. I think that the board meeting was delayed for about 2 to 3 hours, because myself and Mr. Molefe were fighting over this matter. And in the interest of progress, we then agreed that no, let them be reinstated. I then said to him, it's fine, I'm going to reinstate them, but I'm going to charge them in that case, which is what happened. So I called them back, I withdrew the dismissal, and then I immediately gave them the letter suspending them pending a disciplinary case. So we had discussions about that, but these matters were not personal matters as far as I was concerned. They were about PRASA. Someone sabotaging PRASA's decisions and then programs.
Can I ask you, at the time you wrote the email of the 18th of May, the one we've talked about, you said you had decided that Mr. Dingiswayo must go. You had already made up.
I've already made up my mind, Chair.
And was that the same with regard to Martha?
To Mathangoy.
So we know now.
Just 1 second, Mr. Sonia. Okay, thank you. You may proceed.
So we know now in relation to both of them at least, you had decided on the 18th that they would go.
The 18th is the day I wrote my email.
Yes.
Yes, no, I had already formed that opinion, Chair, that they have to go.
Was that the same with Mr. Kuzwayo and Mr. Gangia as well?
Yes, and many others, Chair, many others.
Okay.
And many others, Chair, so yes.
Now, we don't then need to read too much more of this part of Mr. Bingazwayo's affidavit. He says that there was a debate, a conversation at 14.11. Says he went on to, Mr. Montana went on to say, the only thing we could discuss was how much I would accept for my contract to be terminated. Did you tell him that?
Well, I can't remember that, Chair, but it's possible that I have. Because I wanted to be fair as well, but I made it very clear. We can't work together.
And he said that if you are going to terminate my contract, I am not going to be a party to an unlawful termination. Did he tell you that?
Now, Chair, it sounds like someone I know that you present yourself as brave. No, he was unhappy, Chair. He was unhappy.
Yes.
He looked unhappy, but those words were not uttered as far as I remember, Chair. No.
Okay. Then he says you told him that he could wait for his letter of termination or indicate where he would like it to be delivered. Did you tell him that?
I think, Chair, if I recall well, I'm not sure if his letter of dismissal was ready. I assume that because the letter would have been drafted by the legal department, not by me. And then, so the actual meeting took place, he got a letter, but I can't recall exactly now, Chair, that was that very evening or it was the next day, Chair.
I guess if he says he got it the following day, you wouldn't take issue.
No, I won't take issue with that, Chair, no.
But you say it was prepared by the legal department?
Yes, Chair, I think it was the legal department or the HR, our group HR, yeah.
Okay, well, I'm just
On my
wondering-
instruction, Chair.
No, I accept that. I'm wondering whether, seeing that you were dismissing him and him being in the legal department, and you intended, as I understand it, to dismiss Ms. Ngoye as well, who was the head of that department. I'm wondering whether you would have asked the same department to prepare his letter.
Yes, Chair, but the drafting of the letter, I think, yes, I think it should have been the legal department.
Okay.
If I'm wrong, then it would have been our
The HR.
HR team that drafted the letters.
Okay.
But I invited them.
Yeah.
I think I did explain the reasons.
Yeah.
And say, craft it for me.
Okay.
And then I signed the letter at the end, yeah.
Okay.
Before you had decided to terminate their services or after? In other words, when you asked them to craft the letter, was the crafting merely to say, I've made up my mind, just put it down in writing to comply with whatever? Was that your state of mind?
Yeah,
Well, as I
I
understand-
decided on this issue.
As I understand the position, Mr. Soni, I think at the time that he wrote that email, he had made up his mind.
Yes.
Indeed.
These were the people who were on this campaign, and he would get rid of those in regard to whom he had the power to get rid of them.
Yes.
And the rest that was happening flowed from that.
the indeed.
And I assume that your question may therefore be making the request or giving the instruction to the legal department or HR to prepare the letter, whether it would have been ahead of meeting Mr. Dingiswayo that evening and telling him or after.
No, Chair, I think it would have been after my meeting.
After
with
your
him.
meeting with him?
Because I think, I can't recall, but something I think happened, Chair, and that is why I called him to say, because I asked for him.
Yes.
He was not in the office.
Yes.
I was told he had left. I said, no, I want him to call him. And that's what we do, of course, with senior managers.
Yeah.
Sometimes we call them.
From home.
And I learned from the best, Chair, when you said Mr. Oleman must come back even if he's gone home.
Can I ask you, and I just want to be clear about this. Before you had made up your mind, you had not talked to legal or human resources to dismiss Ms. Bingazwayo, Ms. Ngoi, and the others.
Chair, I think if I recall well, because I used to have what you call one-on-one meetings, and more specifically with the HR executive. I did mention, because the situation in the business was deteriorating. There was a lot of tension, there was a lot of infighting. Even our own executive meetings were split in between, in the middle. So I think, and I knew what would be the advice that would come, Chair, and I think you've summarized it so well, that suspend these guys, go through a process. But I believe the job of a CEO is to evaluate, is it in the best interest of the company? Will the disciplinary process be a further point of mobilization for all these forces that were there? And Chair, you know, when I met with the chair of the board, where we discussed this matter 2 hours before and we had 2-3 hours delay in the board meeting, I kept on asking the chair, I hear the principle that you are making, Chair, but have you become a shop steward for some of these people in the business? So if you look into where PRASA was, Chair, I think that it was not normal. It was not a normal environment, and that it's unfortunate. If you ask me, if it was a different environment, but I've sat with executive chair where I've asked some of them to leave, and the way I do it, I'll sit with them and say, look, we are going this way, and I think you're going that way. I'll give you an example with one of the ICT executive. I would sit with her all the time and say, look, we have employed you as an executive, not as an ICT specialist. So we have put you in a leadership position, and you are not operating at that level. You keep on dropping. So you can coach, you can consult with people, say, I want you to operate at that level for us to achieve our objective. These are not junior employees, Chair. These are people that are highly paid, and they should operate at that particular level. And we need to be very careful that whilst the principle is important, I think the principle outlined in the law must be respected at all times. But I think there is instances where when people don't, if Mr. Dingiswa was making mistakes or was taking decisions that I do not like, as a general, I would understand. I'm saying he was actively part of a process to undermine the company, Chair. And why should they get the benefit of a good policy of PRASA about this disciplinary process? I don't believe in that. I believe that you must weight up this particular issue. So I respect, Chair, what Mr. Son is saying. I don't dispute with that, but I think I'm trying to convey as honestly as possible that I've taken a decision that these guys must, if they are off the way, and maybe even the kind of thing that was happening with the chairman of the board would even perhaps even change.
Okay.
And this is my last question on this. You did consult the head of HR. They advised you against doing this, but you weighed the situation, you examined your duties as the CEO, and you decided that you were going to go through with the decision, with your decision. Would that be a correct
So
summation?
that's a correct summation. I agree with that.
and he says at 14.12 on page 105, this meeting was very short. I had driven for 30 minutes one way for a meeting of about 5 minutes.
Yes, Chair.
That must be correct. I mean, and it's not I'm just saying, putting the hard facts down, that must be correct.
I don't think, Chair, it took 5 minutes, but I think the value of it was in our discussion more than the.
How long
If I were to take the 30 minutes into account, it means I have to build a compound inside PRASA for these executives to sleep there, so that when I wanted to consult with them, they're immediately available.
No.
But more or less, the principle, I think Mr. Dingiswa is correct. It didn't take long.
How long did the meeting?
Well, 10, 15 minutes, I think, yeah, more or less. Yeah.
All right. Then he deals with Ms. Ngoyi, and we'll deal with that when we deal with what he says about her, because this is now.
But I'm sorry,
reported.
Mr. Soni,
Oh, sorry.
something, just remember something. You said you were looking for Mr. Dingiswayo, and you were told, I think you said he had left. And then you said they must call him. That raises the question, why couldn't you wait until the following morning? Is there something that had happened that was quite urgent for you to call him all the way back?
Actually, I think, I don't think there was something that, I think I'd taken the decision that day.
That was the last
And that was his last day. I'd made that I was going to execute that task that
Yes.
very day.
Yeah.
And I think I was probably in many meetings.
Okay.
And by the time I was looking for him,
He had
he had left for home.
Okay.
And that's what I called him.
Okay, all right. Mr. Soni.
As you please. Let's leave 14.13 and 14.14 out, because as I say, they deal with Ms. Ngoyi, and we will deal with her tomorrow or later this afternoon. At 14.15, he says Mr. Montana's reaction, and he gives 3 possible explanations. One is you were temporarily irrational, you were overly invested in showing that your word was final, or you were overly invested in the transaction and was intolerant of anyone who saw the screaming irregularities in the transaction. Now, the only reason, we don't need to accept the correctness of what he is saying, but what is quite clear if you look at the email of the 18th is that your email was in reaction to the Prodigy contract. That is correct.
That's correct.
So, in other words, when he says there's a possibility that you were invested in this transaction, it's not something we can exclude. We would have to put it onto the equation, because we know now at the time you wrote your email that you were writing it in connection with questions that had been raised about Prodigy. I accept the general background you've given, but I'm nevertheless saying that the chairperson, when assessing if there is a link, would have to take that into account. Would that be correct?
Well, Chair, no. I think let's be guided by evidence. Mr. Dingiswa wrote and said people were people at and I said
General acceptance.
No, not the general acceptance, but in another one where he said when the CEO approved this thing, some people misled the CEO. And so you can see, Chair, that there's a lot of turns and twists in all of these things.
That was in relation to the Prodigy contract.
To the Prodigy matter, Chair.
Okay.
Where he wrote in an email. Okay? Now, if we take it to its logical conclusion and talk about invested, so it meant, therefore, that some of the paragraphs that we dealt with, they now get a different meaning we'll have to go back because it will actually mean that here's a man who's accusing the group CEO of something untoward. Okay, and it is dealt with. So Mr. Soni, if we take it to its logical conclusion, we'll have. I assume that the commission will be driven by evidence. We'll check, for example, why Prodigy, why not 6 other companies, and they're in my affidavit check, the many other companies that were left, and why he's been silent on many others. And I'm saying there's only one explanation. It's because it has to do with the list of companies that they've identified, not through structures of the company, not through the board, of which I'm a member, but on the side, and then try to implement. And so I think my responding affidavit to Rule Point 3 on Mr. Dingiso actually I'm putting it actually in a light-hearted way. Actually, I'm putting it very strongly in a written word, Chair. So yes, if the commission evaluate, and I presented evidence to the commission, and it takes that, of course, Chair, it means that I've got the right to go to court and say, but I've given the commission this evidence. And on what basis did the chair of the commission ignore this evidence and exercise my right in that respect? And the same applies, Chair, to what on Friday we discussed in respect to the contracts. You remember I said that you've got judgments where, for example, there are scathing statements about me by the courts. But I was also denied the right to put my view. So that if the commission will have to take that into account. It's the same principle. But I respect that. I don't think, for the record, Chair, I was invested in any of these companies. And in fact, despite the fact that I was one of the most investigated people, Chair.
Sorry, the most?
Investigated persons. And you see, Chair, this will become clear when we discuss particularly the Oleman's report that was here. And they still cannot find, Chair, whether law enforcement agencies or whether investigations appointed by PRASA, they are struggling to find. They can point out, oh, there it was an irregularity. There Mr. Montana made a mistake. But they cannot accuse me of any form of improper conduct or corruption, Chair. It cannot be.
Now, Mr. Montana, Mr. Wire doesn't say, as part of the investigating team and legal team, we would, of the commission investigating process, we would have to take into account all relevant facts. Can I put this to you? If you look at page 138, and you don't need to go there, that's the letter from Ms. Shanmugam to you inviting the partnership between PRASA and Prodigy.
Did you say 138?
138, yes.
The one that I wrote on?
Yes.
In detail.
Yes.
Okay.
And you immediately on the same day said the proposal must be accepted.
Yes.
That's the 10th of June 2010. Is that right? Now, independently of this, the Commission has evidence that Royal Security, which is a company owned by Mr. Roy Moodley, and we've been through that already, had between July 2007 and June 2009 paid an amount of 64,000 Rand monthly to Mr. Zuma as an employee of the Royal Security. Are you aware of that?
No, not at all.
Okay, I'm saying to you, we have the bank statement to establish that. One of the questions I want to ask you, just arising from investment in this, and of course the allegations being made that you favored Moodley. This contract that is now the subject matter of a court application and that has caused the dismissal of 2 people in legal, namely Mr. Ngizwayo and Ngoi, comes a year after Mr. Zuma becomes president and Mr. Moodley has stopped giving him 54,000 rand. I'm asking you to comment because there must be room to say there could be a link between them.
So I don't know about the relationship between former President Zuma and Mr. Moodley. You know, again, I deal with it in my affidavit, the specific issue of royal security. Royal was not appointed by us. Us, I mean, when I became CEO and the board that was led by Sfiso Telis. In fact, there was an investigation done by, I think it was Deloitte, to look at the security companies that were involved with PRASA. And it found that the majority of those companies were in fact appointed in the 1990s, before there was even PRASA. So, and more specifically, Royal Security. It was involved in railways in 1991. Now, Chair, and how does it come to PRASA? It's because when Metro Rail and Shosholoza Mail were transferred, in terms of Section 197, we had to take all the employees and we had to take all their contracts, all the Metro Rail contracts. That's how. So we didn't appoint Royal Security. It has already been there. And then who recommended for these security companies to be extended? Our friend Tiro Holele and people like Matangoye in the Bid Adjudication Committee. Now because there's a fight, Chair, because there's a fight between myself and the chairman of the board, they're on the other side. What do? Then they tell the chair, this is Montana's corruption. They don't tell the chair that we recommended this at this particular. So I think there is no leg. Even when I consulted the legal and the investigating teams of the commission, one of the things they mentioned was that Mr. Oloman said, among the issues that you're going to touch, Mr. Montana, is about what you call the security syndicate that runs PRASA. Chair, PRASA doesn't even have that. It's got so many security companies that are mainly regionalized. They're not actually operating at a national level. They're more regionalized, appointed at that level, and they attempt to elevate Royal and say that Royal was then getting paid by PRASA and then to sustain or to support former President Zuma. It's just so false and so founded. It's not based on fact.
Okay. Ms. Montana, perhaps the question was clumsily put. I was not suggesting that Royal itself, Royal Security, had been improperly appointed. There is no evidence. What we do have is Prodigy is irregularly appointed. I'm saying that's the allegation.
No, Chair, I do not accept that. That is why I say, Chair, that Prodigy, and that is why in my response to my email, I said Prodigy is properly appointed, it's within our right to enter those partnerships. We may not have gone out on tender, like we don't do. You know, Chair, confinement is an integral part of the policy of PRASA, where for specific reasons, we'll then say we are confining business to that particular entity, or is the only one that has got either the know-how on it or some other reasons. So Prodigy was not improperly appointed chair. What has happened though is that as an afterthought, I think people try to find reasons because Prodigy was part of a company that people believed belonged to a network of Roy Moodley.
But Mr. Montana, you must, in fairness to me, listen to the question.
Yeah.
I said there are allegations. I'm not saying it was.
Yes.
That Prodigy, and you know, because Mr. Dingzwayo has raised that already.
Not with me. In his
No,
affidavit, yeah.
I understand, but you've seen here.
Yeah.
Now, I'm merely saying that given that Commission is obliged to consider, is there a link not because not because Royal Security was improperly appointed, but that a company linked to Mr. Moodley, who has been financing President Zuma, is now given a contract over which a cloud has been put. I'm not saying over which there is a cloud. That's the only point.
But if we go that route, Chair, then you're going to have a problem with, you're basically saying the criticism of this commission that is targeting certain people, that Zuma has been targeted. You'll see, Chair, in one of my submissions, I deal with the ANC battles, particularly on the security companies. Okay? I mentioned the company of Mr. Spiwe Nyanda, okay? GNS Security. I think that it was also mentioned here in Transnet, even at PRASA. But you'll not hear, Chair, a lot of these things because people look at who stands where in the divide. But I don't think the commission should approach this issue. If there are irregularities in the appointment of Roya, let the commission deal with those facts. If there's an irregularity in the appointment of a Prodigy, let's deal with that. The link, the link I was trying to be linked to even President Zuma. If you look to many articles of the staff for the investigation done by for example, Waxman, they tried to link some of us to President Zuma. They say no, even Mr. Molefe, when he was sitting there, you actually said in his evidence, part of state captures that people are appointed to serve particular interests. And you know what was my post on Twitter, Chair? I said, well, I was appointed by under the cabinet of President Mbeki. I was appointed in 2007 as a CEO of the South African Rail Commuter Corporation. Am I captured by President Mbeki? So I hear what Mr. Soni is, but I think we'll be treading on some dangerous ground that actually may invite a lot of criticism to this commission. And I don't think that's where we want to go there, Chair.
Well, let me say this, Mr. Montana. We have, as a commission, we must keep an open mind. We must keep within our terms of reference. We mustn't try and manipulate any evidence to put certain people in a bad light or to create a foundation for certain findings to be made against people. And we mustn't close our eyes if the investigation suggests that we should pursue certain people, I'm saying pursue certain people, but investigate allegations against it. But we mustn't do that. In 2018, I think it was during the second half of the year, we started the hearing of oral evidence in August 2018. There is a note or memo that I sent to the head of the legal team, Mr. Pretorius, and the head of the investigation team, Mr. Nombembe, where I dealt with a number of things. But one of the things that I said in that letter was, it is very important for the investigators of the commission and the members of the legal team that when they investigate whoever, irrespective of what their position may be at the moment, irrespective of what their position may have been in the past, and irrespective of what their position is likely to be in the future. That's in black and white, which I sent to them. That is what I have always expected the investigation team and the legal team to do. It's in black and white. Now, of course, as the as we investigate. Sometimes people will accuse the commission of certain things, even when they know that they can't put any evidence before anybody if they are asked to put the evidence. But sometimes the reason why they do that, like something like, you know, the commission is factional, it's pursuing certain people and not other people. It's in the hope that the commission will start not to do its job properly when it comes to certain people, because it is scared that people will say, you see, we told you, they are factional. Now, my approach is that we must do what we are required to do. In doing so, we must be fair, but that doesn't mean we must agree to everything, but we must be fair, you know. I told you last week that I'm happy that you came and you are putting your side of the story. I don't know what you think, but I think in all probability, you do feel that you are being heard. You know, you are being heard. We don't say we don't make mistakes. Along the way, we may make mistakes, but it doesn't necessarily mean that we have certain agendas. And I'm hoping that I wish you had come much earlier, because maybe other people might have seen that, well, if you go there, you're allowed to put your side of the story, and you will be heard. You know, whatever happens about what findings will be made, but the process, you will have been heard, and that has got its own important place as well. So, yeah.
Chair, thanks very much for that. I think there's also assuring words, I think, to many people out there. As you know, the commission is being debated politically in many platforms, in many circles, and all of those things. Chair, let me explain why I put it that way. You know, when you look, and I think at some stage we'll deal with the Werksman's investigations and reports. You look at all of what had transpired. When the time comes, you'll actually see that there's been this attempt to link former president to PRASA. You know, and for some reason, I don't know why I can't run away from President Zuma. In 2007, my first year as a CEO of PRASA, I had to write a letter explaining myself to the then Minister of Transport, because there was an accusation, Chair, that I'm using PRASA to support a faction in the ANC, the Zuma faction against the Mbeki faction. Chair, I was so angry. I wrote angry letters, and the minister had to counsel me and say, calm down. We're in the middle of a political storm, and don't get inside it, let it pass. But Chair, I can assure you of one thing. I've checked all our major contracts. All the Werksman's reports have been leaked to certain journalists, Chair, and you'll see what they've written and what the report says. In some instances, using the same word. Because they've been trying to link Zuma to Sufambo, Zuma to Siangena, Zuma to Royal Security. When you look specifically at PRASA, Chair, you know, the only time anything that brought us closer even to the Guptas would have been the SABC program in the morning. But other than that, Chair, we've never had that, and that is why I said on Friday, you'll never find Zuma or the Guptas lacking behind any of the programs that we've implemented. So I want to be hanged, Chair, for my sins. I don't want to be hanged because I'm linked to, people think I'm linked to Zuma for some reason. And that is why in 2007, as a CEO, I had to produce all the tenders that we had managed to prove that we have never funded the Youth League or anyone else to propel President Zuma to office. So, Chair, we've been subjected to all of those things. But I think moving forward, we have to overcome that and also continue to forge unity among South Africans So that some of these divisions, we overcome them, Chair.
Yeah. Mr. Soni?
As you please. Mr. Mutana, can I just ask you, because I want to finish now with the contract itself, and I've raised one part that involves Mr. Woodley and you. The question I want to ask you is, do you know over the period of time that PRASA was in a contractual relationship with Prodigy, what amount in total it paid to Prodigy?
So, Chair, I wouldn't have the total amount. I don't know. I don't know, Chair, as I sit here.
It is something we ought to look at, you accept.
Yeah.
But let me ask you a related question. PRASA would pay Prodigy because that was the complaint seemingly that was raised with your office, whether you were aware of it or not, that it hadn't been paid. And PRASA would then, as I understand what you have said, claim that money back from CETA. As PRASA, while you were there, did PRASA claim back all the money it was entitled to from CETA?
Chair, I wouldn't know. One of the things, for example, that I'm raising in my affidavit, I said there was a time when Mr. Allen Genge, who was responsible for that, in fact, didn't claim some of that money. And actually, I was chastising, I was responding to Mr. Deniswa, that if there's one issue where somebody neglected his duties and didn't do the work. So if you chase this issue, chase all of them together. So I don't know how much was we got from both CETA's Chair. I wouldn't have checked that, but I think the annual report of PRASA of that time, I could go and verify and check the numbers, because they'll give us a sense as to how much was claimed from the skills levy. But we did include Prodigy, Chair, into our PRASA's skills plan that we submitted. And once you submit the report, then that's when you get paid. So yeah, but I'll check, Chair. I'll check. I'm not sure how much was recovered by PRASA.
Sorry, it's just one final question on the contract itself. I take it that in respect of training, Prodigy was not the only contractor who could provide the type of training that PRASA needs.
Prodigy was not the only company providing training services to PRASA, but there are areas where Prodigy was the only accredited on some of the programs, and I deal with that in my affidavit. And there are instances where PRASA used Prodigy's work to apply for funding from TITA and allocate that money to other people. I also provide that in detail. So this matter is more complex than we may be fighting, Chair, battles of managers at PRASA about who's better, who do we fund better, because that's my sphere of influence, than actually dealing with the real issue. I highlight that in the thing. So it was not the only one, but there are areas and there are certain competencies where other service providers were not accredited, or vice versa as well, Chair.
Now, the Constitution, and you must know this, Section 217 says that when an organ of state procures goods or services, it must do so in terms of a system that is fair, transparent, and equitable and cost-effective. Was there any assessment of the cost efficacy of services that Prodigy was providing compared to other service providers?
Chair, let me deal, you quoted Section 217, which of the Constitution. And Chair, I just want to draw, because I think...
if you want to look at it, a copy can be provided.
No, I don't,
Just
I
in
don't,
case,
no, I don't need the copy, Chair. No,
Yeah.
I know, thanks very much, Chair. I know it very well.
Yeah.
And I'll tell you why. I know it very well because I was part of the Department of Public Works at the time when the Constitution was drafted, and we had a direct input into that process, Chair. It's unfortunate. Section 217, the way it's being interpreted, Chair, has become an instrument to undermine transformation in the country. I deal with that at length as well when it's used in broad brush. Indirect, it's used in that way, Chair, incorrectly. Okay? So I think this reference to 217, as a country, we need to be very careful. Because at the time when it was drafted, Chair, there was actually an ongoing battle in the country, particularly within our National Treasury at that time, Department of State Expenditure, Department of Public Works. We had started implementing certain measures, Chair, which later, of course, had to be incorporated. The triple PFA, Chair, was to give effect to some of the things that we're talking about. It also became an instrument to undermine all of those things. This particular matter, Chair, and many others that are mentioned in the Public Protector report, in no way undermines Section 217. And I deal with that, for example, when you look at the Siangena matter. I deal with that when I look at the Public Protector matter. And I think, Chair, it's been used in a way that doesn't assist us. Both the Constitution, the triple PFA as a law, the PFMA, they recognize that entities will also have policies, and these policies will give effect in one way or the other to what the Constitution had intended to achieve. And you'll see, Chair, that the PFMA itself recognizes that there are instances where you may have, for example, procurement without, because when you say a system that is fair, transparent, and competitive, people have now reduced that to say you must go out on tender. No, it doesn't mean that, Chair. And so that's how this broad brush, and I think the prodigy contract, Chair, even when I look back, if I were at PRASA today and we had this kind of an offer of this nature, would I sign it? Yes, not everything should go out on tender, Chair. And if this country doesn't understand that, we are not going to make any, we're not going to win as a nation. So Section 217, Chair, in my application, my review application on Public Protector, where I deal with errors of law, I deal specifically with how Section 217 tends to be misunderstood. And because of my background in public works at the time and our input into the constitution-making process in 1996.
But let's be more specific, because you will recall that I was saying Mr. English-File should have said why these contracts, he was saying these contracts were invalid, or certain people were saying these contracts were invalid. That includes the prodigy contract. You said earlier on the tender process was not applicable because this was a partnership. Now, in effect, is that the ground on which you say 217 did not apply? Is that correct?
No. At that time, 217 is raised now as a question, Chair.
Yes.
I never dealt with it in respect of prodigy.
Oh, okay.
But I've raised it, I've dealt with 217 in relation to other matters, specifically the Public Protector report.
Yeah, okay.
The point that I made, though, at the beginning, Chair,
Yes.
was that did we have to go out on tender
Yes.
for an offer that we received? And I say no.
Yes, yeah.
And I still maintain that position,
Yeah,
Chair.
no, that's
and it's
fine.
not in violation of 217 from where I sit, Chair.
Yes, but I take it that that's because you say this offer was an offer of a partnership. Let's partner together on this. I take it that that's what you mean. And you are meaning for offers of partnership, you don't have to go out on open tender.
No, not all of them, Chair.
Yeah.
Let's say you have I think at that time we're discussing an unsolicited bid.
Yes.
If you have an unsolicited bid, your company is gonna run that project, pay for it, and all of those things. You may then have to look at what Treasury rules, regulation says in that particular respect.
Yes.
So I'm not saying in general, and that is why,
Okay.
Chair, earlier on,
Yes.
we dealt with the issue of the 2010.
Yeah.
And I think my point was misunderstood.
Yes.
I was not dealing with the award. I'm saying once FIFA, for example, comes into the country,
Yes.
when they contract with PRASA for train services and all of those things, there's no tender process, Chair.
Yeah.
There can't be a tender process.
Yeah.
FIFA owns the World Cup.
Yeah.
It's their own event, Chair.
Yes.
So you can't go out on tender.
Yeah.
The second report of the Public Protector, Volume 2 of the raid, drafted by Advocate Mkhwebane, it dismissed all the matters but found on one, Chair, that, and it says the complaint is sustained. The same PRASA and Transnet, when PRASA got Mjanchi House, which is an old railway building, PRASA should have gone out on tender. Now, Chair, the law says you go out on where it's not practical to do so. You can't. We want Mjanchi House. It's part of a railway station. We want to run our operations there. Now, a state-owned company cannot go to another one and say, let's transfer that building. We are told it doesn't actually create value, Chair. So I'm simply saying there are instances where either a partnership, for example, we had a partnership with FIFA. We couldn't go out on tender, Chair. But of course, was it transparent? Yes, it was transparent. Was the pricing a competitive one? It was, yes, a competitive one. So I'm simply saying, Chair, that not everything we do, we are reducing everything to tenders. And that is why there's all this big fight about tenders. But on this one, Chair, I do not hold the view that it was in violation of the PFMA or Treasury regulations, and most importantly, Section 217 of the Constitution.
I think, Mr. Soni, because I kind of read where you were going with the question, 217 question, I think you need to just put it on the table so that it can be dealt with properly. Yeah.
Mr. Montana, whatever it is, you accept that they were competitors to Prodigy who could provide those services. The very same services, and I know you say that there were some only Prodigy could provide, but there were other services which other services could provide. You've already said that is correct.
No,
Chair, let's not go into the world of speculation. Let's be very specific on this.
Yeah, maybe let's do it this way. Well, Section 217 talks about whenever you're going to procure goods or services, what Prodigy was going to do was provide services, or you say no. They're going to train your employees.
No, Chair, I'm not going to change. I'm not changing.
No, I accept that, but I just want us to see, go step by step. Do you accept that Prodigy was going to provide services to PRASA by way of providing training, or you say no, that's
Chair.
Not services? Prodigy
is appointed or is given an award by a CETA, and it decided to partner with PRASA. Now, Section 217, I want to link it. It requires us to put in place, when we buy goods and services, a system that is fair, transparent, competitive.
Yeah.
And Chair, the policy of PRASA, it defines that system. Unless if including, of course, where we don't go through competitive tender process.
Yeah.
It's part of those systems. It's part of that system. And therefore, Chair, unless if you say, Mr. Soni would say to me, you as a group CEO, you didn't put in place, okay, a system of that is fair, competitive, that meets Section 217, and that I'll challenge there. Chair. But a confinement or an exception, Chair, doesn't mean that that system is not in place. And so we are taking one contract to define the system, and
Yes.
that's where my challenge is. Chair.
No, I understand what you are saying. You see, as I understand these procurement laws and regulations, you have a general rule. And the general rule is, if you are an organ of state and you seek to procure goods or services, you must go through a fair, cost-effective, competitive process. Okay? Now, then you have regulations or policies or treasury instructions which say there are circumstances where you are entitled not to follow the general rule. So there are exceptions to the general rule. One of those is if you are faced with an emergency. You know, I don't know if they use that term, but if you are faced with an emergency, there is no time to invite tenders of bids, so you can go to one service provider and say, hey, there was a storm here, this is what has happened, and they fix that. That's accepted. It's permitted to do it that way. And then there is a situation where they say if I think they call it a sole source situation, where that provider of a product or service is the only one that provides that type of product or service. To say, in other words, it won't serve any purpose to invite the bids because this is the only one. Okay, then there may be other exceptions. Okay, but those exceptions kick in because you are trying to procure goods or services. If you were not trying to procure goods and services, then they would not kick in, and you would not even use the general rule, because it falls outside what the tender system is there for. Okay. So when I was asking you whether you accept that what Prodigy was going to do in terms of this contract was to render a service, it was meant to see whether if we go step by step, where you are going to say, yes, I accept that part, and then maybe you are going to say, but there is an exception. One of these exceptions to the general rule is what I rely on. That's what I was trying to do.
Yes,
you understand?
No,
this?
Chair, I hear you clearly, Chair.
Yeah. Okay,
and I think in principle, yes, I agree with you.
You agree? Okay.
When we take a decision, Chair,
Yes.
that we are going to go that route,
Yes.
and that must apply unless if there's exception.
Yes.
Of course, there are also where it's not practical to do that for whatever reasons.
Yeah.
Chair, if you look at we go back to
So maybe before you proceed, therefore, what I'm looking for, and I suspect what Mr. Soni may be looking for too, is which one of the exceptions that are known to the general rule you may be relying on, or whether the position is that we don't even get to the exceptions because I say this is not goods or services. That's what we are trying to do.
Chair, I think that for me the starting point, because even that was not. I need to reflect to the Commission what was the thinking at that time.
Of course,
and,
yes.
And we debate.
Of course.
And that is why we call this a partnership. Because you say here are two organizations. Of course, the starting point is whether Prodigy was properly appointed by, because that's where the capacity or the skills, that's where different organizations or service providers in training compete to provide for that. The money comes from this particular entity. This, what is called the services seat, is the one that says, we appoint you, you are going to do this for us. Then they go and partner with whoever they deem suitable for that. Now, Chair, that is why I was putting that in the realm of all other sorts of partnerships that we have. And with what you are raising, it actually raises a question that even some of the partnerships that we have, would we define, or that we had at the time I was there, would we define them as goods and services in that sense? And it may require a rethinking, Chair, but from where we stood at that time, this was a partnership. It didn't require that kind of a route. And I think of 4 or 5 other partnerships that we had entered into at that time, that even though there was money, there was some kind of service that was being used. But I'm not sure, Chair, that it takes you to a point where PRASA had identified a need. Because people, remember, Chair, part of the issues that we operate also in a commercial environment. People come with ideas, people come with proposals. And I think it's because of that you see Treasury trying to now regulate that in the form of unsolicited bids and putting regulations to manage that. My view, Chair, is that when I look at this, I don't think that it falls into that, and I think that maybe the fine line that we have been drawn between a partnership, or, I mean, look at how people, for example, abuse the issue about emergency procurement. Is there, and everyone will try to find the reason for it to be an emergency, when in fact it's not an emergency.
I've had quite some evidence.
In the Chair.
Yeah.
You know that in the PRASA environment, when we deal with the issue of Siangena, we deal with the 2010 World Cup emergency in January 2010. So, yes, Chair, I think that my view is that the Commission will have to evaluate this in total and say what was the thinking. But from where I sit, I think that there is a space. The public protector ruled on one matter involving PRASA, where there was a partnership, and said that it should have gone out on tender. I'm not sure if I agree, Chair, but I think we just have to evaluate the entire evidence and maybe that would be one of the recommendations where the Commission say, you want to amend that part, make it clear, structured in that way so that there are no grounds where people can either manipulate or there's no clarity on it. At the time we're in there, Chair, and I think I'll have to check. There are certain things, Chair, and I don't want to say Prodigy will fit on one source. Because that's not what we discussed at that time. But if you look at these capabilities and what it was able to do, somebody was going to come and say, but did you check it, did you test it to the market? So I don't want to go to that extent, Chair, because that's not, we thought, let's enter into a partnership, and the written word is there, Chair, from me. Written in my own, it's my handwriting, and I said, look, let's enter into an MOU. I'm not sure, Chair, that violates, or the intention was even to violate 217 as it stands in the Constitution.
So, I just want to summarize what I think you are saying, and then you can say whether my summary is a fair summary. You are saying, at the time, you took the view that this was a partnership, and that where an organ of state is getting involved in a partnership for something to be done, there was no obligation to go into a tender process. Is that correct?
Chair, if you may repeat that.
Okay, maybe now I remember something that you said earlier on. Okay. At the time, you took the view that this project, this project that Prodigy wanted to get involved in with PRASA was going to be a partnership. Is that right? That's point one. Point two, you took the view that this particular one did not require PRASA to go into a tender process. So I must just clarify here whether your position was that all partnership, as long as it is a partnership, you don't need to use an open tender, or whether you're saying some partnerships, and this was one of them, you don't have to go through a process of a tender process.
Chair, recall earlier on, I was talking about some partnership depending on the conditions under which they happen.
Yeah.
For example, here, the deciding factor is Prodigy is not coming to PRASA and saying, we want to do training.
Yeah.
He's saying, we've been awarded this thing.
Yeah.
We want you to work with PRASA.
Yeah.
Of course, I think the issue that maybe Section 217 or of a competitive fair process will come when we then move beyond the 300. For example, and say, does it arise?
Yes,
I think, Chair, there is a big question. I never thought about it at that time.
Yes,
With hindsight, I think that question may arise.
Yes.
Is this when PRASA bought Umjanji House from Transnet, PRASA made a conscious decision that we are buying this building from Transnet because the process of a Section 54 of the PFMA may take long to transfer that business through getting government approvals and all of those things. And we knew that we were buying that building not from any other, we're not looking for any other building. We wanted Umjanji House located where the main rail operations are, which is historically a railway building. So we're not buying any other building. So, Chair, that design, when we did Bridge City, Chair, that development, the land belonged to the city of Durban, plus, and it had taken that land, entered into a partnership. Now, when we wanted to build our station under the mall, we couldn't go out and tender. It was not practical. We couldn't do that. But when we did a phase linking Bridge City to the entire railway line, we could afford to go out on tender because that was practical, that was possible. So you make decisions on that basis. So here, Prodigy says, I've got this thing, I'm offering to PRASA. Once you accept the Chair, it's not any other. And it means, of course, that the sitter had its own process on why they gave that to Prodigy and not to someone else. But if PRASA decide that we are going to train 5,000 people, PRASA decide, and this is going to be our requirement, it is obliged to follow, to go out on tender and that will check. So these are not the same, and that's the kind of explanation I'm trying to provide.
Yes, no, I understand your explanation completely. So the deciding factor, it seems to me from what you have said, in relation to the first 300, was that Prodigy had been appointed or awarded, I'm not sure what the correct term is, by the sitter, had been awarded a certain amount of money that had been put aside and had been in effect authorized to go and do training. Anything else really didn't make any difference. That is what made a difference to you. Is that right?
Indeed, Chair, because I think that they were bringing in not only the award, yes, we also have to go and check. At that authority, when it gave Prodigy this thing, Chair. I think
whether
there are certain competencies, there are certain things, Chair, how many companies were given an opportunity to do all of those things. Once we've got all of that, Chair, we'll then be able to come to a determination to answer the question that Mr. Son is raising. But as I see it right now, Chair, you ask me, do I think, and I think there's somewhere I wrote, I think there's an email, where I say that, but how do you want a partnership? Because for me, the partnerships, we even regulate in terms of a different policy, not the SCM policy, but the sponsorship policy mainly.
Yeah.
But people have said, they've criticized us on the World Cup because they applied. And I think the SCM policy chair is not an overarching policy of a business. It's one policy of a business. Sometimes you find conflict between some of them, and we tend to reduce everything that, no, here's the standard. And I don't think that is that should be the case, Chair.
Yeah, okay, all right. So you used the word partnership to say going out on tender doesn't apply because this is a partnership, but in the end you say, you know, the fact that the SITA had given Prodigy or had awarded or appointed Prodigy, that was what made a difference in my own mind as to whether we should go out on tender or not.
Because the bursaries chair belong now to Prodigy.
Yeah.
So if it agrees to work with us, it's effectively ceding that to us.
Yeah.
So
yeah.
it is bringing something to the party.
Yeah.
What is it that, and that's where the business relationship starts.
Yeah. Yeah.
When FIFA comes into the country and it runs the World Cup, chair, and PRASA doesn't say, we are going to advertise services for the World Cup. We enter into an agreement, a partnership with FIFA because the rights, the branding belongs to FIFA.
Yeah.
We want to become a party into that.
Yeah.
The same happened in Bridge City. There's some of my executives were saying, but PRASA as a state-owned entity can expropriate land. I say, but where have you seen something like that? The land, the leading party in the partnership between the city of between the city of Durban and is a sphere of government. We can't take that land over just. So we couldn't build our railway line, or rather the station, outside of a development. We couldn't bring a contractor and say, we're advertising services. Appoint a contractor who comes and dig in someone's land. We have to agree with that person and say, part of the development of the mall, we want it to include the station. So we won't go out on tender on that because it's not practical, Chair. You can't bring contractors to build a mall and then build contractors to build an underground station on that mall. So because then even from a structural point of view, you're going to have a problem. But if PRASA decides, Chair, on its own, no offers of any kind from anyone, that it wants to train a number of people, it is obliged, Chair, in terms of that, in terms of the procurement laws of the Republic, to go out in that route.
Yes. And then just to complete, because you touched on the 3,000, you already said, well, you didn't think about it in that way at the time.
At the time.
But when it comes to, when it came to PRASA expanding the scope of the arrangement with Prodigy to include the 3,000, maybe that's where PRASA should have gone out on tender. And you said at that time you didn't think of it that way, but now you think maybe that's what should have happened.
Chair, I think it arises.
Yeah.
And there are two ways of dealing with it.
Yeah.
The first one, we may say, no, we think for this one, and let's terminate, let's go out on tender.
Yes.
You may lose the values and the benefits that you've acquired from that,
Yeah.
because they may not translate. So from a cost point of view, you are losing the benefits. Remember, the issue is value for money at all times.
Yeah.
The second option should be say, no, so that it's transparent and it's fair. Let's subject it to what
The
is
process.
it called? To the process. Now,
Yeah.
that doesn't mean a tender, necessarily, Chair.
Yeah.
It means that let the adjudication committee looks at it and say, because, Chair, this is very important. So you may go out on tender, you may want to ask for an increase in the scope of that work. And I think that these documents are telling us all about that, Chair. So yes, I accept what you're saying, Chair. It may, the extension of that scope and the numbers may actually invite that question, Chair,
Yeah,
which
yeah.
at that time we're not dealing with.
Yeah.
But as you speak today, I do recognize that, in fact,
Yes.
the scope may be big, the
Yeah.
numbers may be different.
Yes.
And therefore,
Yeah.
you may want to go through that process. Chair.
Yeah, okay, all right. Mr. Soni? I'm hoping there is clarity that has emerged.
There is, Jefferson, I don't want to unnecessarily
Yeah,
go into trivial matters.
Yeah,
but
no,
There
no.
are two matters that arise. Can I ask you, Mr. Montana, to please look at page 138? That's the invitation from Prodigy to you.
Page 138.
138. That's MMD 3.
Yep.
Now, in the second paragraph, it says Prodigy has been awarded bursary funding for 300 learnerships from the from the services CETA via the discretionary grant process. That's what they say.
Yes.
Can I ask you this? You accepted this on the very same day. And I know there were discussions previously because they say that in the first paragraph.
Yeah.
Were you involved in those discussions?
No, not at all, Chair.
Now, were you aware whether it was only Prodigy that had been awarded that bursary funding? Because when I look at this, it doesn't say it was the only entity awarded that funding.
Yes, Chair, I don't think it was the only one, but I think that the Prodigy is the one that came to PRASA and say, we want to use ours with you. The others may have used them in other environments, but yes, I don't think it was the only company.
But then I'm saying to you, Mr. McConnell, that it is not for us to water down the strict wording of the Constitution. We're not talking about ordinary law. We're talking about the fundamental document that determines how public authorities conduct themselves. Now, if Prodigy was not the only entity which had that facility, isn't there, and I'd like you to look at it now, isn't there the necessity to say, are there any entities, and should we not look at Section 217 so that Prodigy is not unfairly given an advantage because it simply approached?
Chair, I think, and I want to build on the conversation and the discussion that we had earlier on, Chair. Because I think my comments on 217 in my review application, which is part of my annexures to the commission, is very clear, Chair. We have to decide. The Constitution says that. The Constitution also says the organs of state will then implement these systems that we have. Because I don't think it can be, Chair, that we say systems of how would I put it, a fair, transparent, competitive process.
Cost effective as well.
Cost effective as well, indeed. Process. And we say that the organs of state are required to put that in place. When and then we have the PFMA. We have, for example, the triple PFA, which both of them give exceptions and exemptions as well to what is happening. Now, Chair, I think what we should be, because I think also, so that we don't also speculate about the issue, we've got to do three things. The first one, we need to assess, to evaluate that which other companies were given, and specifically for what competencies. What are the areas where, for example, Prodigy had these competencies and where others didn't? Or they were given the same thing, Chair. That's the first issue. But I think even if there were 2, 3 other companies, if 2 other companies also approached PRASA, and PRASA then rejected them and take Prodigy, that would have been unfair. But we don't know of any other company, Chair. But I don't think, because the CETA deals with a whole range of other things. My view would be that perhaps the Commission may want to raise that issue with the services CETA and say, give us an input, tell us about this organization. Who had these things that when you gave, because that will help us share. That's the first issue that is there. But I do not share the view that any offer of a service requires a tender, Chair. And if you say it doesn't require a tender,
I think you mean every. I think you are
offer of a service,
yes,
because some level of service is involved, Chair.
Yeah.
But it doesn't mean every time you buy,
Yeah.
you procure goods and services, the tender is a route to go. And I don't think that was the intention of 217 either. But I think as a guiding principle, it is correct, I support that, but not in all instances, Chair.
Yeah.
And where organizations come to the party, not for you to buy services to them, say, we want to work with you here. I think, Chair, let me give this last example, Chair. There's a school, there's an NGO called Kutrano. It trains young people in maths and science. And we partnered with them. Now, and that is about, we want to position PRASA. Again, this is regulated by our sponsorship policy, not by our SCM policy. And so, as you raise the Chair, I realize that there may be instances of conflict or that there's no clear line between, and we may have to look at that again.
Yeah.
But for now, I still maintain, Chair, that I think that here we got a better deal with the Prodigy.
No, that's fine. I think what we should do, what should be done, Mr. Soni, is this. I understand Mr. Soni to be saying, at that time, I didn't think that there was an obligation on PRASA to go out for tender in regard to the first 300. As I sit here, I still have the same view, but because of the discussion, I think it may be that we should have, but we didn't think so. I think in the light of that, what should be done, we should just get all the facts that we can get. So the suggestion, which is that let us establish how from the CETA, how these so-called bursaries, because how they are awarded, and the contracts, because I see in this letter, Prodigy said they were attaching a copy of the bursary contract. They say a copy of the bursary contract, yeah, but it's not attached yet.
Sure.
So because the terms of that contract, which must be, I guess, between the CETA and Prodigy, might affect these issues that we are looking at, you know. And you remember earlier on I was asking Mr. Montana as to the process of payment, because I was trying to see who is obliged to make the payment. Because on the one hand, Mr. Montana was saying this meant that the CETA had set aside money for training, but it had not given Prodigy the cash. But at the same time, I was hearing that PRASA would be paying and claiming back and so on. So it's important to just get the actual facts. How does it work? and so on and so on. And then once we've got all of that, as well as including what actually happened in this particular case when the SETA awarded Prodigy the so-called bursaries, the bursary funding. And then once we have got all of those facts, then I think we can deal with the issue properly. And it would be important that at that stage we hear your comments, Mr. Montana, because then you would also be having those facts. But I think in regard to the 3,000, you are much closer to making a concession than you are with the 300. I think you are closer to making the concession there.
No, Chair, I think I'm saying that when we look at it in the light of this discussion,
Yes.
it may be, unless if, and that is why I'm saying there are two routes.
Yes.
If it was extended without any of those processes being adhered to, whether an open tender or you going through an adjudication committee to get it passed there, then of course you didn't follow a process.
Yes, yes,
but if the scope was dealt with by an adjudication committee and it recommended that it be approved, Chair,
that would be different.
That will still be within that system of governance that we want to put in place.
But basically, you're dealing with these two separate because the training might be the same, different categories of people being trained, but the process is not exactly the same. So you are saying that it looks like, well, you are saying, I think, you are not sure whether in regard to the 3,000, the process that you followed included taking this matter to the adjudication committee of PRASA. And you are saying if you did, and that committee said, go ahead, or something like that, you would say it was lawful. But you are saying if that did not even happen, then you would concede that then you didn't follow.
There are issues that change.
Okay.
But even, Chair, when the adjudication committee would have said yes, the commission having taken all the evidence on the SETA Prodigy matter, may still then want to obtain an opinion and say, is this meeting the test of 217? And then all of the matters are considered. My fundamental point, Chair, is that where an entity, private or public, brings something, you can't take out something to tender that doesn't belong to you. And that's the point I'm making. Prodigy owned the bursaries. They are not PRASA's bursaries, Chair. So we couldn't take them out on tender.
No, I think that the point you raise when you say, what is the effect of the fact that the state awarded Prodigy these bursaries, this bursary funding, it is a legitimate point to look at. That is why it becomes important also to say, if there were terms and conditions to which governed this award to Prodigy by the SETA, we ought to know. I mean, if, for example, the SETA said to Prodigy, we are setting aside this funding for you to train staff falling within the following categories at PRASA and that company and that company. It may be that you say, well, the SETA has chosen us, so how can we say, let's go to tender?
Indeed.
So now, I don't know, because I don't know this contract between Prodigy and the SETA. I don't know whether that was the position or not, you know. So I think it's a legitimate point you have raised. Let's look at it, let's get all the facts, and then we take it from there.
Mr. Montana, just finally on this, page 138 and 139 is Prodigy's letter. And I'm just dealing with the letter, not your inscription on the letter. You will see that The heading of the letter is Piloting of Center of Excellence Model and Learnership Implementation. If you go to page 139, in the middle of the second paragraph, they say, should Prodigy be awarded the contract to pilot the Center of Excellence model, it would assist PRASA in accessing the aforementioned funding window. The point I'm trying to make is, nowhere here...
Which paragraph are you on?
Sorry, on page 139. The
second paragraph from the top.
Yeah. It says in the second sentence, should Prodigy be awarded the contract to pilot the Center of Excellence model, it would assist PRASA in accessing aforementioned funding window. The point I want to make, Mr. Montana, is it's just because you've raised the fact or the question that they were offering you a partnership. There is no offer of a partnership. The first mention of a partnership, Mr. Montana, is in the second sentence of what you write, where you say, we should enter into a partnership with Prodigy. So the idea of a partnership comes from you, not from Prodigy.
Do you want my comment?
Yes.
No, Chair, I think let's read the first paragraph of that letter. Because I don't think there's any inconsistencies here. I think that we're dealing with the word. It says further to discussions held from March 2010 with respect to the Center of Excellence model, Prodigy hereby convey that it is able to provide PRASA with 300 funded learnership that will fast track the piloting of the Center of Excellence model. Now, Chair, so they're giving us something. In return, we accept what they're giving to us and say we'll use that to start our Center of Excellence. So Chair, I think I don't think that maybe Mr. Soni is trying to say Prodigy didn't use the word partnership. Yes, it's used in my notes there. Not I don't see it in the letter that is there. And I then said we must enter into a formal MOU in respect of this matter. So whether you call it, I call it as a form of partnership. And I think the paragraph that the sentence that Mr. Soni read, it actually talks about if should Prodigy be awarded the contract to pilot the Center of Excellence. Again, even the word contract, in that particular respect, I don't know, in any agreement that you formalized or is you reach agreement on, even if it's verbal or written, it will be a contract. We've entered into partnership where we've signed contract, and we refer to that in that way. So Chair, I think for me, my handwriting notes, my notes there, are quite consistent with both the letter and spirit of what Prodigy is offering there.
Well, Mr. Montana, I don't want us to debate this. I'm going to disagree with you. There is no consistency between what you have proposed and the proposal from Prodigy. We will disagree on it, and at the end of the day, it is a question of interpreting what they have said, your response to it. And I just want to point out that if you look at MMD4 on page 141, you will see that what emerges is the partnership agreement, not the contract to pilot the Center of Excellence that they had proposed in their letter of intent.
But if we again, Chair, I'm glad that Mr. Soni say is a matter that we can debate and on. I'm using two words. I'm using partnership. And then later on, I use the word MOU. Now, if we follow what Mr. Soni is saying, it therefore means that the MMD4, it could have been a contract, a partnership, or it could have been an MOU. But we're giving effect to one and the same thing that is proposed in the letter. And Chair, why did I write on top of it? Because this was not a secret. I didn't even know that 5 or 10 years down the line, we'll be sitting here debating and looking at my words. At that time, we've received this offer that the 300 bursaries awarded by the CETA, can it be used at PRASA? And we use that to as a springboard for our Center of Excellence. And Chair, we've accepted that, and I think for me, that is the essence of what you said, of what we wanted to achieve. Did it need to go through a tender? Again, Chair, I'm saying...
let's look into it.
Let's look at that. I think we've discussed the process, and I'm quite... I think that's my view on the matter, Chair.
Yeah. Well, let me confirm this. When one reads this letter from Prodigy, when I read it at least, I get the impression that PRASA wanted to pilot its Center of Excellence or model, excellent model. That's what PRASA wanted to do. It gives the impression that it so happened that Prodigy was looking for an entity whose employees it could train because it had been awarded this bursary funding. I'm saying that simply because of how the letter is worded. Further, that is first paragraph, further to discussions held from March 2010. It looks kind of like discussions that may have been going on for some time with respect to the Center of Excellence model. Prodigy hereby confirms that it is able to provide PRASA with 300 funded learnerships that will fast-track the piloting of the Center of Excellence. So it gives me the impression that you wanted to pilot this model, and they happen to want an entity whose employees they would train, and then there was then they made this proposal, which is if you let us train your staff, you will benefit because then your project, then you'll be piloting your Center of Excellence. Is that what happened? Is that
Chair,
a fair reading or not really?
Chair, I think I'll say yes and no. It is quite clear to me, Chair, when I look at this letter, that this letter was a culmination point, was not the beginning. So we don't have, as you sit here, details of the kind of discussions that took place between PRASA and Prodigy prior to this letter, because that is very important. And secondly, we do not have the details of the basis and the terms and conditions of the award by the city. We are offered this thing. Within that, we reach an agreement. So we need to look at that, because that will then tell us and answer Mr. Soni's question. And ultimately, the bigger question about, is this in violation of 217 or not? Or should be dealt with differently? So I think a more factual approach will help us to come to a common determination on it. But when we approved it at that time, Chair, I think that Prodigy was putting something on the table, and I stated earlier on that they were not just giving to us just in Mahala, Chair, because it's quite clear that their business is training. So if they link that with our center, of course, that they're in a strategic or in a better position to even do more. So that's the nature of the animal, Chair.
But I may have asked this question before, because I was trying at that time to establish who actually ultimately and in effect paid Prodigy for the training services that it provided to PRASA employees.
No, it was PRASA, Chair.
It was PRASA,
Yes.
even in regard to the 300.
Chair, no,
Because I'm
no, I
talking
don't
about
think
the
in regard
300.
to, no, the rest of the other training, Chair, the first one, I think it was, you recall, Chair, was a model here. They offer you, you train, you recover the money.
Yes.
So both for the 300 and the 3,000,
Yeah.
PRASA would recover the money from the different sitters. You remember the other money is not only coming from the services sitter, it also comes from the transport sitter.
And the sitter that they are talking about here is which sitter?
For the 300, it was
The
the services
services
sitter. Yeah.
sitter.
But the
Yes.
others, the other 3,000 was not part of that. That will come from the.
Yes, but what I mean, the sitter, the services sitter, put aside a certain amount of money
Yeah.
for Prodigy to conduct training. Prodigy ended up, or rather, conducted training in respect of initially 300 employees of PRASA. Now, I would expect that they were paid through the money that the sitter put aside.
No, Chair, PRASA will spend the money, but they'll still recover that same money from the city.
But will spend the exact amount of money that the sitter has put aside or what?
No, Chair, it could exceed that amount. You
Yeah.
remember, CETA tells you about what it can fund, but that may not be the real or the total cost of training.
Yes.
So if it's beyond that, even what you claim, you're not going to get everything that you claim,
Yeah.
but you can get a large chunk of what you spent
Yes.
onto that project.
So what is the difference between a company such as Prodigy coming to PRASA without being awarded bursary funding by the sitter and saying, we would like to train your staff, we think that you can benefit from the training that we can give to your staff, and for that service, we are going to charge 100 million rands or whatever. What's the difference between, because in the latter case,
Yeah.
obviously they must look to you for payment. Now, if they've gone to the sitter and the sitter has put aside money for this training, is it still PRASA that ultimately pays them? So what's the need to go to the sitter?
With regard to, I think this is linked.
The 300.
Yeah, this is linked to a skills levy, Chair. But you are raising an important issue. I mean, the other question linked to what you've just raised is, why doesn't sitters, for example, why does it have to go through service providers and not, for example, link directly with PRASA? And I think the question is, who has got the skills? We run trains, we run buses, we run property, and therefore we may not have the, what is it called, the necessary accreditation in those areas that are there. So that is why we've got those service providers. Is it a more efficient model, Chair? I think that it's another question. Perhaps the sitters should as a first line, say public entities or other organs of state, here's money that you can access, you can apply. And part of that is happening, Chair, where you can apply. But I think that there are certain areas where you do that through the service providers. I don't know what's the rationale, the logic, Chair, that's not my space. But I know that we're being offered to use the services. So we have to then check under what circumstances was this offered,
Yeah.
what were the terms,
Yeah, I think
and then we clarify that question.
I
first,
think we
Chair.
need to find more information, because for me, if you say you're granting a student a bursary, that means you will pay for them. You'll pay for their studies. So this says the sitter awarded Prodigy bursary funding, provide training. So I have difficulty understanding how it could come about that then PRASA must pay in full for the training. I can understand if the arrangement is the SITA will pay a certain percentage and then PRASA must maybe top up or whatever. But we need to establish that, because also in terms of who is going to make the pay, who will pay, who has the obligation to pay, that might affect the question of whether we are dealing with a tender situation or not. If in effect PRASA is not going to pay, or is going to pay a very small amount, so we will need to just get information on that. I certainly don't know much about how SITAs operate. Yeah. Okay, all right. We are at 4:15, to the extent that, because I think it's clear we are not going to finish with Mr. Montana. There is a witness that is scheduled for tomorrow, but he won't be long. So we might have to decide whether he should come in the morning, we finish with him, and then Mr. Montana continues if he's available, or whether we ask him to come later in the day. We start with Mr. Montana. Are you available tomorrow, Mr. Montana? You say you are under someone's.
So you put me in a very difficult position. Mr. Sony had confirmed that
But that will finish
by
today.
5 will be done. The commission will not want to see me here again, Chair. Chair, I don't know, I'll be guided by you.
Yes,
And
yes.
and perhaps we can try to do the other 2 remaining matters tomorrow.
Yeah, no, that's fine. So, I think that's good, because we would like to try and finalize, and I'm sure you would like to get to the end of the process as well. So let's take a break now, 10 minutes break. We'll come back and continue until 5, and then we'll adjourn until tomorrow, and then hopefully we finish tomorrow. But I think what is important is that issues are being dealt with.
No.
We are doing justice to the issues, and that's important. Yeah. Okay, let's take an adjournment. It's about 17 minutes past 4. Let's resume at 4:30.
As you please.
We adjourn. You might be too far from the mic, Mr.
Sorry,
Soni.
Chairperson,
Yeah.
sorry.
Is it possible to bring that mic of yours more to the center? Because I think you do move away from it and it's
Yes.
right at the corner.
Yes.
Yeah.
Okay.
Okay. If that won't interfere with you.
No,
Yeah.
no.
Okay. All right.
Mr. Montana, at paragraph 14.17, Mr. Dingiswayo says that after he was dismissed, the SLA that he had reservations about was signed on the 29th of May. Is that correct? This is at paragraph 14.17 at page 106.
Yeah, I don't know the date, but I know that the second addendum was signed by Ms. Coker. But also I don't know the specific concerns that Mr. Dingiswayo had. Chair.
Okay. He then raises certain questions about the enforceability of the contract. We don't need to debate them now because and the only reason, Mr. Montana, is that whole matter is before court at the moment. We've agreed on that.
Yeah.
Right. I then ask you to look at paragraph 14.21. He says in September 2017, and has been corrected on this, it's in February, March 2017, that was the evidence. Ms. Shanmugam, now she's the lady who wrote to you, you might remember, asked to meet Mr. Holele to discuss the issue of payment. Says, however, it was not Ms. Shanmugam who attended, but Mr. Mudley. Mr. Holele and Mr. Achote, a general manager, represented PRASA, and he says Mr. Holele will deal with that meeting. I don't know if you have followed the evidence given by Mr. Holele. In fact, he was the first witness called in respect of PRASA. And what Mr. Holele said, I'm just raising it for you why Mr. Mudley looms large in these proceedings. Mr. Holele said that Mr. Mudley said to him, you know, you better be on the right side of history because there's going to be a change in the ministry and there's going to be a major change at PRASA. And he used a term that is going to come up again, or it certainly came up when we dealt with what happened on the 20th of August 2015. He says that young man is coming back. Mr. Holele saw that as a reference to you. Are you aware of any of that?
Mr. Holele is younger than me, Chair. I don't know when they say young man, he assumes it should be me. He's far younger than me, Chair. You know. So surely I thought he would be looking at someone else. Chair, I don't know. I saw Mr. Holele's testimony where he called me a dictator. And I heard him making the statement, but I'd left PRASA by this time, I think 2 years earlier, so I don't have direct knowledge of what was discussed in the meeting.
See, what for the Commission is not without significance, and I'm not saying it is of extreme significance, is that 3 weeks after that meeting, Mr. Paul Peters is replaced as the minister. And I'm just saying that as a commission, these are not matters we can ignore once that evidence is before us. And so to the extent that you think Mr. Mudley is being focused upon, the reason is because there is those pieces of evidence as against.
Okay.
Now, in paragraph 15, he says that Mr. Mujola conducted an investigation into the prodigy contracts, and it is a report that is in fact annexed to the to his affidavit. I'd just like you to turn to page 128, which deals with the report. I don't want us to look at the whole report, but just two parts of the report or three parts of the report. If I can ask you, the report starts at page 128, and I'd like you to turn to page 135. And
did you say page 135?
Page 135, as you please, Chairman. In paragraph 5.1, Mr. Mujola in the report says, there is a number of witnesses who are yet to be interviewed and submit statements to this matter. From statements obtained, it is clear that former PRASA technical CEO, Mr. Saki Zamkaka's statement would be critical to this matter. What was Mr. Zamkaka's role at PRASA?
No, Mr. Zamkaka, Chair, was the, well, I don't know, of course, here, he was the CEO of our technical division. And I assume, therefore, that the part of the training happened with his team, Chair.
What part of the training?
I'm saying that PRASA Technical is one of the divisions of PRASA. He was the CEO.
I see. It happened, yes. Now, just relating to Mr. Zamkaka, I'm going to go into something we're going to deal with tomorrow. One of the properties we're investigating is the Parkwood property. In that property, there was an addendum to the sale, your sale to Precise Trade of that property. And it is recorded in the addendum that Mr. Zamkaka was, in fact, a tenant in that property. Is that so?
Yes, sir. It was my property. It was put there by me, Chair.
Okay, so he was renting from you.
Well, Mr. Zamkaka, Chair, I don't want to discuss his personal matters, but for some personal reasons, he was going through a process, and he rented, of course, a place in the city center of Johannesburg, from Pretoria, and I didn't even know about that, Chair, because he didn't tell me. It was none of my, it had nothing to do with me. I needed to see him one evening. I couldn't find him, and I knew that he lived in Pretoria. I was also in Pretoria. And I could only see him the following day. Then he told me and explained, he couldn't come. And I realized that we have one of our CEOs who was actually living in the middle of Johannesburg. And I identified a risk. And then I arranged and said, look, I've got a property that I've just developed. If you can stay there in the meantime, whilst you're trying to sort yourself out, Chair. So there's nothing, it's got nothing to do with Mr. van der Walt or anything. It was me offering a brother a place to stay whilst he was going through a particular phase in his life, Chair.
Okay. Can I ask you now to look at paragraph 5.4?
Chair, before we move to there, Mr. Soni, I see you're jumping 4.18 above. Can I read it out to you? It is evident that former Group CEO Lucky Montana was determined to have Prodigy conducting training for PRASA regardless of company policies and tendering procedure. Here's a report. Someone has not even, I've left PRASA 2 years in. I don't know who this Mr. Majola is. Has not even interviewed me. But he can make that kind of statement. I mean, these are the type of things that we're talking about. He doesn't know me, but he knows that Montana is determined. When I look at the word determined, Chair, he doesn't even mention the fact that he didn't even interview me. Yet he make the kind of statements about me, which I think that I'm going to look at the conclusion. And he leave it at that, Chair. It's not even part of his conclusion. It's in the body of the report. He makes a finding. So I just wanted to bring that to the thing. It happened after I've left PRASA. 2 years later, he never interviewed me. And I'll have a problem with a report like that, Chair, as a starting point.
Yes. And now that I didn't want to raise matters relevant to you, but can I ask you to look at 415 now that you've raised it? He says it is evident from statements obtained that it was deliberate not to follow SEM tender process to employ services of Prodigy to conduct training for PRASA. And there would be constant communication breakdown between PRASA managers and Prodigy, and that is the reason Mr. Montana brought Ms. Kondowe to rescue the process. I'm just making the point that he does make some adverse, but I didn't refer to.
No. Chair, I see that, and that's what conspiracies do, Chair. When you formulate these things in your head, and they become, sometimes you create this thing, Chair, with your own hand, your own labor, and it becomes a fetish, something that you start to worship, because you think it has got power over you. Yet you have created it as a product of your own labor. We are seeing it in this report, Chair. Ms. Kondu worked for PRASA for a very long time in HR. In fact, I think she joined Metro Rail before there was even PRASA. I think she was part of South African Airways, one of the highly experienced HR executive or senior managers in that environment. So why was she brought in to rescue anything? So you can see that I'm not surprised why 4.18 comes in, Chair, because here's a guy who doesn't even know me. He's probably never even seen. He only knows my name from reading reports, and he decided to write something like that. What was she rescuing? You see, Chair, I mentioned earlier on when we were dealing with the affidavit of Dingiswayo that there are insinuations, but we are not told what it is. Now there it is. I'm bringing her to save something. What is it that needs to be saved? I'm asking myself, Chair. So these are the type of things, and unless if this chap is asked to elaborate and assist the Commission to understand what is he saying in this report, I think that is something that shouldn't be taken lightly, Chair.
Yeah. Well, I was looking. You commented in respect of paragraph 4.18, which you read out. In regard to that paragraph, you commented that what he was saying there was not even part of his conclusion. But I went back to see what heading it falls under. I see that it falls under findings. So what he is saying there is a finding. I have not read this report recently, so my memory is not fresh on it, but from the markings that I've made on it, I think it would have been dealt with earlier. But I see also that I see it's a progress report, but I see that in paragraph 4.2, which is at page 133, it says, it is evident that there was no tender process followed to bring Prodigy into the PRASA system for the training project, and all decisions which were made and taken in respect of this project were in favor of the service provider. And then under 5, which has the heading conclusion, 5.1 says there is a number of witnesses who are yet to be interviewed and submit statements to this matter. From statements obtained, it is clear that former PRASA technical CEO, Mr. Sakeza Mxaga's statement would be critical to this matter. 5.2, there is a host of documents and records still to be retrieved from different offices or employees in order to complete this investigation as per the scope. Yeah, there are others. Well, it just what attracted my attention was that the investigation appeared not to be completed yet, because he said there were still a number of statements or witnesses who were still to be interviewed. But I see that he says it's a progress report, but I was just noting that. Yes, Mr. Sorry.
As you please, Chairperson. Then at 5.4, he says, there is a general feeling that from some managers that Prodigy training of PRASA employees was not worth the money which they had been paid, which had been paid to them, as it did not benefit the business in any way. So that's a view that has been expressed. You obviously hold a different view. You said so at the outset, that they produced and they improved the business of PRASA. Is that correct?
Well, Chair, I don't know. Someone who's been since 2017, I don't know Majola to what extent he was involved with these processes, what he has, what evidence he has looked at. I was just noting, I don't even want to comment because I don't know what was the purpose of this report, but I see attacks on me that are so unjustified, that do not have a basis. But Chair, I don't want to take up on this report. I was just noting, picking up points as we're speaking, Mr. Soni.
Yes. And then just finally, I want to refer you to 5.5, which reiterates what is said, I think, in 4.2, and it reads, although the investigation process has not been completed, it is confirmed through the statements obtained that there was no SEM tender process followed to employ the services of Prodigy for this training program.
I think, Chair, that has been the subject of our discussion.
Yes.
Yeah.
And the question, as I understand it, is whether, given the nature of the relationship and the contract that ensued, Section 217 and the tender process was triggered. Would that be a fair summary of what we've been debating?
But I think the summary that we made earlier on, particularly on that getting the right information to be able to make, to enable the Commission to make an informed determination and come to 217. I think Majola's report, Chair, is that Jabulisa Majola. I don't think Chair is someone who probably was not senior enough or was not aware, is an investigator who looks at who probably wanted to know the facts without looking at the bigger picture. But I wouldn't dismiss it. I would allow it that we can test all of everything he says once we have obtained that information that we asked for earlier.
Yes. Finally, in regard to Mr. Dingizwayo, Mr. Montana, I just want us to look at paragraph 19. It says, based on the foregoing, I submit that PRASA is under a duty to press for the settings.
Which
sorry.
page are you in?
Oh, sorry, page 110, back to his affidavit.
Oh, back to
sorry.
his affidavit, okay.
Yes. Mr. Montana.
The chair, 110. Okay.
Right at the bottom, paragraph 19, he says, based on the foregoing, I submit that PRASA is under a duty to press for the setting aside of the contracts and resisting Prodigy's claim for payment from PRASA. I further submit that Prodigy was favoured because Mr. Roy Moodley exercised such undue influence over Mr. Montana and other senior employees who supported the manner in which Mr. Montana ran PRASA for the benefit of certain individuals and entities he was close to.
Chair, I think throughout the day,
I haven't even authorized that it should be before me now.
Yes, Chair.
But
Well, perhaps
let's leave that. Let's leave that part.
Yes,
Who is
being
here?
collegial, Chair.
Yes. Who is here?
Good afternoon, Chair. My name is Tsidiso Ramachale.
Yes.
I appear on behalf of Lieutenant General Peter Jacobs.
Yes.
We have brought the application that the chairperson is referring to, and I'm not sure by way of procedure whether you'd want us to move the application now and to provide our reasons for why the application is late, but we are in the chairperson's hands on that.
Yeah, well, I haven't read it in the first place. Why should it be dealt now before I hear Dr. Dintwe's evidence?
Well, Chairperson, our view is that the application need not be heard today.
Yeah.
Provided, of course, that the relevant parts of the application, which we've brought, in essence, an application to strike out certain paragraphs from Dr. Dintwe's.
Oh, why must they be struck out?
The grounds are irrelevance.
Yeah, but that's none of your business. That's the Commission's business.
With respect,
If the Commission admits them and they are irrelevant, it doesn't hurt you, so why is that your business? It would be different if they hurt you, they infringe your rights, your client's rights.
Well, what's
But
the
just that they are irrelevant, yes, this is not litigation where you are a party, this is an inquiry.
yes, no, Chairperson is correct that this is an inquiry, but we are
Yes.
entitled, if the Commission is being drawn to facts that are not within its purview, to
Yes.
object as such.
No.
And
If they don't infringe your rights, your client's rights, it's just that they are irrelevant, I don't see why that should be your business. That's what I'm saying. It's different if you say they infringe our client's rights.
Well, no, Chairperson, the argument we make is the test, as the Chairperson is well aware of, is
Yeah.
one of prejudice, and the scope of prejudice is quite wide. It's not necessarily that the person has to be directly adversely affected by the
Yeah.
allegations. And what we say is that the allegations made in the affidavit are in fact damning.
Yeah.
Before we even make our submissions on whether they are true or not, we say that they are irrelevant to the Commission's mandate.
Yes, when did you get the Dr. Dintwe's affidavit?
We got the notice on the 29th of March.
Yeah.
We set out our reasons. I appreciate that the chairperson hasn't read the affidavit.
Yes, but I'm looking at the time. If you got it on the 29th of March, that means today is what, 20th? Today is
Yes,
20th.
Chair.
Then I see that it was signed on the 19th of April,
Yes.
the notice of motion. So where were you for 3 weeks?
So we set out our reasons when General Jacobs was implicated, because he was implicated in his official capacity as Divisional Commissioner.
Yeah.
We had to make an application for funding from the National Commissioner.
Yeah.
And that's what held us back.
Yes.
That's the first reason. The second reason we've advanced is that at the time, General Jacobs was away on annual unpaid leave, and he couldn't cancel and his
He was
arrangements
away
on annual leave.
Yes.
The arrangement had already been made, and he had already paid for the trip with his family. And then
so he went on leave instead of preparing his application.
No, Chairperson, I'll go to the other reasons. When it became clear that he would not be able to submit his affidavit within 14 days, we made a request to the Commission. We wrote a letter to the Commission Secretariat, and we were informed that the Commission is not in a position to grant or deny applications, and that the application would have to be moved with you.
But in the end, apart from saying that certain allegations are irrelevant, what else what other complaint do you have about the allegations to which you are objecting?
No, that's it.
That's it.
So we give a full answer to the allegations.
Yes, yes.
But the only grounds on which we bring the striking out application
Yeah.
is that we say that they are irrelevant to the Commission's
Okay,
mandate.
no. That's fine. I don't think that should be something that should hold up me hearing the evidence. You will be able to deal with the allegations in terms of whether they are true or not, and that I think that's the important thing. As Dr. Tintwe gives evidence, if there is something that I consider irrelevant, I will deal with it as we go along, and Mr. Victorious will also be aware of that. And but that's not something that should hold up the hearing of his evidence. Do you understand?
Chairperson, am I to understand that the application has been denied, our application to strike out?
That's what I'm inclined to do.
Yes.
Based on what you have said so far, that's what I would like to do. Is there any reason why you think I shouldn't do that?
Oh, well, we've provided our reasons. I just wanted to be
Yes,
clear for the record that
yes.
our application has been
Yes,
denied.
yes.
The added application that we've brought, Chair, is to, as I understand, the rules require us to bring an application for leave to produce evidence, which we've done in the same application.
You've done it in the same
We've done
application.
it in the same application, that's right.
No, that would be different. Applying for leave to adduce evidence or applying for leave to cross-examine, that would not be different, but that can be dealt with after.
Yes, Chair.
Yeah.
The only thing I wish to point the Chairperson to is that there's no specific prayer in
Yeah.
our notice of motion for leave, and at the appropriate time, I'll move the application.
Yes. Well, in fact, even on the question of relevance, that if you, from what you are saying, you really were mentioning the issue of relevance, but you apply for leave to adduce evidence.
In addition to that, yes. Chair.
Yes, and you also apply for leave to cross-examine or not?
No, so we
Just to
reserve
leave
our right
evidence.
in that respect,
Oh, you
depending
reserve
on
your
what
right,
the
yeah,
testimony is.
Okay.
But it's a threefold application: condemnation for the late filing,
Yes.
an application to strike out, as well as an application for leave
Yes.
to give evidence.
But what I will say is, I don't think there is a warrant to deal with it now, okay? If you later on, after today, wish to indicate what you insist you want a decision on, other than your obligation for leave to adduce evidence, you must write to the Secretary and indicate. And then, because obviously that can be dealt with, but it doesn't have to be dealt with now.
Sorry, Chair, I'm a little confused now. So is there no decision on the application?
No, I'm saying I'm not going to need to deal with it now, okay? The application for leave to adduce evidence, I can deal with that later. We don't have to deal with now. If there is any other thing that you want a decision on in regard to this application, other than the application for leave to adduce evidence, you must let me know in due course through the Secretary. But there's no need to deal with it now.
No, understood.
Yeah.
Thank you very much for your time.
Okay, thank you. Okay. Bring the relevant file. Yes, Mr. Pretorius.
Chair, the witness before you is Dr. Setlomamaru Isaac Dintwe. May he be sworn.
Please administer the oath of affirmation.
Please state your full names for the record.
Setlomamaru Isaac Dintwe.
If you are going to take off your mask when you give evidence, you may as well take it off now. Yeah.
Setlomamaru Isaac Dintwe.
Do you have any objection to taking the prescribed oath? Do you consider the oath binding on your conscience?
I'm sorry, you'll just have to speak up so
Yes.
Your answers can be recorded. Registrar, you are whispering to me.
Should I start from over, Judge? Should I start from over?
Well, you don't have to start from the beginning if his earlier answers were audible, but if you are not sure, then start from the beginning if you are not sure. If you are sure that they were audible, it's fine.
Do you consider the oath binding on your conscience?
Yes.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated, Dr. Dintwe. Thank you very much, Dr. Dintwe, for availing yourself to assist the commission. We appreciate that very much. Yes, Mr. Pretorius.
Thank you, Chair. Chair, you have before you a bundle SSA 2B.
Yes.
In that bundle are 3 exhibits, and the statement of Dr. Dintwe is Exhibit YY15.
Yes.
I'll ask that it be admitted in due course. Dr. Dintwe, do you have Exhibit
I'm
Y?
sorry, Mr. Pretorius. I just pick up something here, and maybe you are aware of it. Dr. Dintwe's affidavit in this file appears at the end,
Yes, Chair.
and I see that I can't see any annexures to it, and yet I understand that his affidavit has got annexures.
Yes. Chair, I will explain the position with regard to annexures
Okay.
in due course.
Okay.
Dr. Dintwe, do you have Exhibit YY15 before you?
I do have.
Would you go please to page, and these are the black numbers in the top left-hand corner, SSA 02775. We will just be referring to the last 3 numbers, but always the black numbers in the top left-hand corner. You see SSA 2775.
I can see that.
Is that the first page of your affidavit?
That's correct, Chair.
Please go to page 835. That's the last page.
I'm on that page.
Yes. Whose signature is that? Above the name Isaac Dintwe, Setlomamaru Isaac Dintwe.
I confirm it's my signature.
Your signature. Are you satisfied that the contents of this affidavit, insofar as you are aware, are true and correct?
I can certify that.
There are no annexures to this affidavit, as the Chair has pointed out. We will explain in due course, but your there are indeed intended to be annexures. Certain of those documents need to be declassified, either by yourself or by the State Security Agency or another appropriate instance, and that process is still underway.
That's correct. I can confirm that, Chairperson.
And in due course, you may return to identify the relevant documents.
That's correct, Chairperson.
Dr. Duntwe, you are at present the Inspector General of Intelligence.
Hang on, Mr. Pretorius. You request me to admit
Yes,
this
please.
affidavit
I do.
as an exhibit?
If you would,
It would be exhibit
YY 15.
YY 15. The affidavit of Dr. Setlo Mamaru Isaac Dintwe, starting at page 775, is admitted as an exhibit and will be marked as exhibit YY 15.
Thank you, Chair. Dr. Duntwe, may I proceed? Thank you, Chair. Dr. Duntwe, you are the Inspector General of Intelligence. Is that correct?
That's correct, Chairperson.
When were you appointed by the President?
With effect from the 15th of March 2017.
And in terms of which piece of legislation were you appointed?
The Intelligence Services Act, Oversight Act, number 40 of 1994.
Right. We'll refer to that as the...
1 second. Yes, Mr. Pretorius, you may proceed.
Before we deal with the contents of your affidavit, perhaps by way of certain preliminary remarks, we can inform the Chair why you are here to give evidence and, in summary, what topics you're going to cover. You are aware of the fact that certain evidence has already been given by or on behalf of members of the State Security Agency.
I'm aware of that, Chairperson. I do confirm that I'll only be dealing with some of the other evidence that was not adduced earlier than today.
And in accordance with the Constitution, the State Security Agency is subject to civilian oversight, correct?
Yes, but Section 210, want to cover the whole of the security apparatus of the country.
Yes.
So
And-
that it will go beyond the State Security Agency. It will also cover crime intelligence, which is a division in the South African Police Services. It will also cover the defense intelligence, which is just a division in the South African National Defense Force.
Yes. So the three arms of state security, intelligence, crime intelligence, and State Security Agency fall within your oversight purview.
That's correct, Chairperson.
And you are currently in office as the Inspector General of Intelligence, performing that oversight mechanism.
That's correct.
Now, you will deal, I understand it, with the nature and functioning of the office of the IGI. The Chair is concerned in this and other fields with the question of oversight. And your evidence will deal with two aspects in regard to that oversight. As I understand it, firstly, aspects relating to the independence of the office of the IGI,
That is correct, Chairperson.
and secondly, the powers of the IGI.
That is correct.
And then you will deal with a number of factual issues relating to your office, its independence, its powers, and how these are dealt with by other statutory bodies or officials.
That is correct, Chairperson.
You will also deal with matters relating to the operational relationship between the Office of the IGI, the relevant minister, and state security, the State Security Agency, and other security instances.
I will also deal with that, Chairperson.
Relevant to the information that you are going to place before the chair, and certainly will place before the chair when the declassification process has been concluded, both on your part and the part of the SSA, is Section 78A of the Oversight Act. You deal with that in paragraph 4 of your statement. What does that provide?
All right. Now, and Chairperson, I have to be careful here because there is a thin line between the two processes that I'm going to try to explain here. The first one is the provision of Section 7.8, which talks about this before any disclosure to any institution or organization outside the OIGI, I am required to consult with the state president and they say any relevant minister. So if it is the information which only deals with the security agency, it will be only that minister. But in this instance, because I'm dealing with information which cuts across the 3 different intelligence services, I had to consult with 4 functionaries, which will be the state president and the 3 ministers, Minister of Police, Minister of Defense and Military Veterans, as well as Minister of State Security. Now, once that process is concluded, then we get to the other one, which then deals with the declassification of information. And I do get my powers to declassify from the minimum information security standard or the MIS document, which then says that the documents can be classified, reclassified, or declassified by the originator. In other words, the author or the owner of those documents. So in the Office of the Inspector General of Intelligence, you'll get different documents. You'll get those that I would have produced as the Inspector General of Intelligence, but you'll also get those that I would have requested from different services. So which means that then I cannot declassify those, but I can declassify only those that I have ownership over.
What is the, if you could clarify this for me, what is the source of the power to make that document called MIS? What is there a provision in some law that says so and so may make this document?
Yes, the position of our office, and I think the other stakeholders that I would have discussed this, is that in fact it's a binding document.
Sorry?
It is a binding document. It
yes,
is a
but
policy.
what I want to find out is what makes it binding, and is it binding only internally within the security bodies, or is it something that does it have legal force? Is it a regulation, subordinate legislation? Is it just a document that reflects Cabinet's decision, or that reflects the President's decision, or that reflects a certain minister's decision, or a decision of a certain group of ministers? Because there has been a lot of reference to it in the past as well. But I've never heard exactly whether it's a regulation that's made under the Oversight Act that you refer to, or where the power comes from to make that document.
Yeah, it started off as a cabinet resolution or a cabinet decision, and then it was used across government because there could be some information that needs to be classified, and it does not necessarily belong to the intelligence services. Even the cabinet minutes themselves, they are classified. So this will be a reference document. But what enhanced its powers, or what made it more stronger, was the decision of Justice Moseneke on the matter of newspapers, on the newspapers decision. And since after that, the Constitutional Court developed some guidelines, and those guidelines were based on the provisions of Miss document. So from where I'm sitting, Chairperson, I will say that it is an enforceable document. It is also a binding document.
Well, unless the Constitutional Court in its decision said that this document is binding, and then I assume indicated on whom it is binding, I'm not sure that you are right, because if it just assumed that it has legal force, because it wasn't necessary for it to decide in that particular case whether the document had a legal force, that might be a different thing. But I assume from what you are saying that you are saying to me, you don't know whether it has any legal force or not, but up to now, everybody treats it as if it has legal force. And when I say legal force, I'm thinking about if it's not part of legislation, then it must be regulations, or if somewhere there's provision to say such a document may be made, and it says who makes that document, and under for what purpose, that then one would trace the origin of the ultimate power or the source of the power for it. But if it's simply somebody's decision, no matter who that person is, who just decided it would be good that we should have a document that sets out A, B, C, D, and that document was prepared. And maybe it does serve a good purpose because there needs to be guideline, but sometimes you need to know, does this document, is it just a document of convenience that doesn't have legal force, or is it a document that has legal force? So that's why I was asking. But I think you are saying, one, it started, as you understand it, as a document that reflected cabinet decision, and then there was the case that went to the Constitutional Court, and you say arising subsequent to that, you understand it to be taken to be binding, and that's all you are able to say.
May I add, Chairperson, to say that that debate is still ongoing. In fact,
there is such a debate.
There is such a debate,
yes.
And maybe what I was providing to you is the position of the Office of the Inspector General of Intelligence,
Yes.
because if it is ongoing, then we also have a particular position.
Yes.
And it is not surprising that as a person who monitors compliance, I would like to have a particular framework which will assist me so that I can go to people and say that, why did you classify this one? Why didn't you declassify this one? As and when that information is required, especially for prosecution. So I think that we will have our own bias, if you like, as an oversight body, to say that the way it is drafted, it can at least take us somewhere in an absence of another legal framework which will assist us with classification, declassification, as well as reclassification. So the debate is ongoing. In fact, we have some minutes somewhere which also reflect that we've been meeting with stakeholders and really dealing with these issues.
Yes. No, that's fine. I was asking because in the context of the evidence relating to IPEL, there was a lot of reference to it when there was the issue of iPad witnesses were saying the police were refusing to declassify documents that iPad needed for their investigations. And in your affidavit, I know that you refer to that as well. And there was this reference to this document, and it seemed difficult to get also. So okay, all right.
Yes, we will address the issue in due course as well
Yes.
from our point of view, Chair.
Yes.
One question in that regard, the MIS document, is it classified?
It is not a classified document. MIS is not classified.
Not classified. We know it's in the public domain.
That's correct, Chairperson.
Right. In paragraph 4 of your affidavit, Dr. Dintwe, you refer to section 7.8b as being the origin of the duty to consult. Sorry, you refer to 7.8a as the section providing the duty to consult. If I may just refer you to 7.8b of the Oversight Act. It's in the bundle of legislation in front of you. Chair, you should have that bundle at page 129. We just need to clarify disclosure and declassification and how they work with one another, or don't work with one another. Section 7 deals with the appointment powers and duties of the Inspector General. You see that?
I see that, Chairperson.
Section 7.8b says that notwithstanding anything to the contrary contained in this or any other law or the common law, the Inspector General, and if we go to B, may, if the intelligence or information received by him or her in terms of paragraph A is subject to any restriction in terms of any law, disclose it only, Roman 1, after consultation with the President and the Minister responsible for the service in question, and Roman 2, subject to appropriate restrictions placed on such intelligence or information by the Inspector General, if necessary, and Roman 3, to the extent that such disclosure is not detrimental to the national interest. And it's instructive that the words national interest are used, not state interest, but that is something that we will deal with in due course. The point is that you have information and you have documentary information which you wish to disclose to the Chair. And the process enjoined by section 7.8b, the consultation process, that is complete, as you will tell the Chair in a moment in subparagraph 4 of your affidavit, or paragraph 4 of your affidavit. But it's the further steps that I want to highlight for the moment. You may then make a decision with regard to the restrictions you place on the information that you wish now to disclose, and you are in the process of doing that.
I confirm that, Chairperson.
And you will consider the provisions of the section, apply them, and in due course produce the documents subject to whatever restrictions you may deem necessary.
That is the correct arrangement with the legal team, Chairperson.
That will allow you to disclose to the Chair. If there is a document that is nevertheless classified at the hands of another state entity, for example, the SSA, before it is made public, declassification would nevertheless be necessary. That's as we understand the position.
That is what, that is my understanding.
Yes.
also,
So,
Chairperson.
Chair, there are two processes that must be dealt with in the compilation of the annexures. The first is the disclosure to yourself of the documentary evidence, and the second is to the extent that it's declassified, we will approach the authorities for the appropriate declassification. If declassification is not forthcoming, then it will only be you who will have access to the document.
Okay.
So has there been a consultation process, Dr. Dintwe?
I can confirm that we've completed that process, Chairperson.
And was it successfully completed?
It was successfully completed, notwithstanding with difficulty, I should mention.
Yes. And have you received any confirmation from the President that the consultative process has been completed?
That's correct, Chairperson. There is a letter from the President confirming that.
And the wording of the section is instructive. You may make your decisions regarding disclosure, as stated in the section, after consultation, not in consultation. As I understand the law in that regard, it means that the decision ultimately is your decision.
That's correct, Chairperson. That is our understanding interpretation of the OIG.
Was that consultative process an easy process?
Not at all, Chairperson. It was a very difficult one. There were letters, in fact, that would have been written to the Commission, which could indicate to the Commission that it was a to and fro kind of a process.
Right. A complaint was lodged against you in relation to your providing information to the Commission. What was that complaint and who made the complaint?
All right, now the complaint came at the time that I was expecting their inputs, because the way the consultation was done is that I provided the three ministers and the president with the bundle, full bundle, and say that I'm intending to disclose this information to the Commission, and I'm trying to comply with 7(8) A, B, and A and B. Now, those documents were gone for about 2 weeks or 3 weeks, and there was an agreement because we were under a pressure of time, a serious one. And the president had directed a particular date. On that date, instead of me getting the inputs, I then received 3 bound documents. And they were under the cover of a letter from the president. The president was informing me that he received complaints from the 3 ministers. Now, Minister Bekicele would have written his own complaint. Minister Nosivie Mapisa-Nqakula would have written hers, and Minister Yanda Dodlo would have written hers as well. But there was a serious commonality between them. Complaint number 1 was that I disclosed information to the Commission before I consulted. And the recommendation that they were making to the President was that I should be suspended and obviously be removed from this position on the basis of incompetence. I think they were referring to that. But I received it on the day that I was expecting the.
Right. So the fact that you had engaged.
Well, you mentioned I thought you said there were 3 complaints or something like that.
Yes, there were 3 complaints.
Was it a complaint about the same conduct on your part, but coming from 3 ministers? So were they complaining about the same thing?
That is correct. Maybe I shouldn't have said complaints. I should have said there were 3 documents.
Yeah, yes. Okay.
With 3 different authors.
Yeah.
But the content, the allegation made against me was
the
similar.
same.
Yes.
Okay. And it was the one that you mentioned.
Yeah.
Yes.
And the allegation.
I'm sorry,
Chair.
He nodded, but that won't be recorded. The allegation that was being made in the 3 documents was the allegation that you have told me about, namely that you disclosed certain information to the Commission before the consultation process.
Yes, Chairperson, but maybe I should have told you that there were, in one document there were 4, in the other one there were 3. Like in the annexures, you will see that. So it will be 3 different allegations coming from Minister Bekitele, for instance. But complaint number 1 will be the disclosure to this commission.
Okay.
I don't mind mentioning the other 2 that were also common. Yes.
Well, if they are not important or relevant, that's fine.
I don't think they're relevant here.
Okay, all right.
Yes.
So the letter that you received mentioned a recommendation that you should be suspended. Did the recommendation that you should be suspended was contained in the complaint by the 3 ministers, am I correct?
That is correct, Chairperson.
You then received a letter from the President. What did he say to you in that letter?
He was informing that he received those complaints that he was attaching them, and that he referred that complaint to the Joint Standing Committee on Intelligence, and that he hopes that they will give me Audi. And with regard to the issue of suspension, he said that he will depend on the recommendation of the committee, the JSCI.
Joint Standing Committee on Intelligence, the
That is
Parliamentary
correct, Chairperson.
Joint Standing Committee on Intelligence. Yes, and all this was happening at the time you were seeking to consult with the ministers about your engagement or further engagement with the Commission.
That is correct. I do confirm that, Chairperson.
Did you appear before the Joint Standing Committee of Intelligence?
That is correct. I went, I was called.
And what was the outcome of that process?
When I was starting to explain to them, and my starting point, my opening point was to say that if this is an inquiry in terms of the Oversight Act, I think that you should have informed me in the letter so that I can also seek legal representation. And then they told me that, no, we decided not to start an inquiry in terms of this particular issue. In fact, they also informed me that they missed sending me a letter that they sent back to the president. So they would have responded to the president already. And they only said that they wanted to only hear side of my story, but it didn't go any far because it became a moot point. On the basis that the Joint Standing Committee on Intelligence was saying 2 things. The first one was to say that the allegations against me were unsubstantiated from the 3 ministers. But secondly, that there were no rules of Parliament which deals with the removal of the Inspector General of Intelligence. So the chairperson of the committee was saying, I cannot start this particular process because we are still behind and we still have to deal with that particular issue.
In any event, has that matter now been put to rest?
The matter has been put to rest now, but not entirely. When the Minister of State Security received the 3 notices, she wrote again to the committee at this time and asking them, how far are you with this complaint? So she repeated the very same complaint again and asked. And then she also attached the Rule 3 notice from this commission as well.
Okay. All right, so that's where that is for the moment. Paragraph 6, you talk of an attempt was made to persuade you to limit your evidence. Would you just tell the chair about that, please?
Yes, so in a meeting which was held between myself and the 3 ministers, which was a very hostile meeting, I should also add, and in the absence of the president, they requested me to give them the letter written to me by the secretary of the commission. Now, in that letter, normally they will just say that you've been mentioned, the office was mentioned by the likes of Ambassador Moshe, Mr. Matetuka, Mr. Gibson Jenje. So the secretary would have written to say that we think that you can come and close some of the gaps that we have in the evidence that was given, taking into consideration the position that you are occupying. But in that letter, there were only 3 points that were mentioned there. The information that was required would be that I should assist the commission in terms of the oversight powers of the OIGI, but also tell them my predecessors as well as the ministers that were actually working at the time of my predecessors. But then you'll get a sentence which will say, and any other information that you think will assist the commission. So in that meeting, the ministers were really fixated on an issue to say that, but the commission has told you what they require from you. And I was telling them that, no, but the commission will not waste time for me to go there and present the Oversight Act. It is the public domain. They can just get that. They've got researchers and so forth. So I said that, no. They wanted any other information.
Any other information.
Yes,
yeah.
and they stood there. It did not end there, Chairperson. The commission would have received a letter and an ACT file where Minister Ayanda then decided to act on my behalf. Such an independent office, act on my behalf to send to the commission the regulations, the Oversight Act, so those copies. And the letter was addressed to the chairperson to say that we are assisting Dr. Dintwe here because it will seem as if he wants to give you more than he would require. So that letter is here, it is also in
Yes,
my bag.
that letter is a matter of record, Chair.
Well, hang on, Mr. Dr. Dintwe. I do remember that I've previously seen a file that has got the legislation and I think regulations and whatever, but I can't remember the background. I would have assumed that I got it just from the legal team, but as you speak, I now think that there was a file that seemed to have come direct from outside the commission that had just that. But I've no recollection of whether it had a covering letter, and if it had a covering letter, what the covering letter was saying. Are you saying that whatever was sent, you did see?
I was copied,
Because you can
Chairperson.
refresh my memory, yeah.
Yes. Okay, I was addressed CB, if you like, CC.
Yeah,
The
yeah.
president was CC, the other two ministers were CC'd.
Yes. It
So-
was coming from which minister?
Minister Ayanda Rodlo of the State
Yes.
Security.
Okay.
And the crux of that letter, it will be somewhere, Advocate Pretorius. The crux of the letter is to say that the commission has requested Dr. Dintwe to provide information with regard to these 3 points. Who was the Inspector General in this year, who was the minister during this particular period, and the legislation, the oversight, and so forth. So she decided to compile it and really demonstrate to myself that it is doable, because I was refusing to do it the way she wanted it to be done.
Yes, Chair. We'll put together that correspondence. It's already in a bundle.
Yes, I
Chair,
would
that
like
correspondence was addressed to yourself.
Yes, yes.
And it,
I would like to see it now, knowing this context, which I didn't know before.
right, Chair.
Okay, all right. So, but is the position that, as far as you understand, what prompted the sending of that file by Minister Dlodlo was that you seemed to be, you seemed not to be keen to send just that. You wanted to give the commission more, or you thought, you seemed to indicate to them that it was impossible to just give them the commission that. It's just that it's an interesting.
It was my intention, and I made them, I expressed to them clearly to say that I'm a person on my own right. I'm an adult, I'm an official of government, so obviously I have to write an affidavit. And that affidavit will not be based on the letter that was actually written to myself. It was based on the brainstorming sessions. So the accusation that I would have disclosed information to the commission prior to the consultation process, it is because I would have sat with the investigators from the commission, and we will just have a discussion just to see which points the commission would have interest on. So it was based on that. So I had an idea already of how my affidavit was going to look like. So I was saying that my affidavit will have to be accompanied by these annexures. And that is the reason why I am then consulting with yourselves. So I was telling them that as much as I would have loved to only send this information, I've made a commitment already during the brainstorm session that I will be able to share information on these other aspects, which were not necessarily in the letter.
Okay.
So to summarize, insofar as there was a suggestion or a directive or however you want to phrase it, that you limit your evidence before the Commission or your disclosures before the Commission, you have decided what to say and the extent to which information should be disclosed.
I have decided that, Chairperson. And it is a critical point because it talks to independence of the Office of the Inspector General of Intelligence, but it also demonstrates how the office has been attacked from time to time. You can imagine, I mean, if I have to deal with certain allegations which are unsubstantiated, it takes about 5 days out of my work to only go and deal with those complaints. So even this one will demonstrate that point, I think, when you go to independence.
Right, because the duties and powers of the Inspector General are embedded in the Constitution and in legislation, it's necessary for us briefly to go through the framework which governs your office. It's also relevant to the Chair because the Chair is concerned about the oversight activities, their successes or failures in relation to the various aspects of evidence that we've heard, and particularly the evidence emanating from State Security Agency witnesses. Paragraph 7, you refer to Section 210 of the Constitution. You see that?
I see that, Chairperson.
And sub B of that section reads that national legislation must provide for civilian monitoring of the activities of those services, those are intelligence services, by an inspector appointed by the President as head of the National Executive and approved by a resolution adopted by the National Assembly with a supporting vote of at least 2/3 of its members. So is it correct that in terms of Section 210 of the Constitution, you were appointed by the President, and that appointment was approved by Parliament in the National Assembly with a supporting vote of at least 2/3 of its members?
That is correct, Chairperson.
Right. And the Oversight Act also provides for another oversight body. What is that?
It provides for the Joint Standing Committee on Intelligence.
And to whom are you accountable in terms of the legislative framework?
The Oversight Act says that the Inspector General of Intelligence shall be functionally accountable to the Joint Standing Committee on Intelligence, to Parliament in other words.
Right.
So
Now,
the Joint Standing Committee of Intelligence chairperson will be like a portfolio committee. But they just did not call it a portfolio committee because this one will deal with defense, will deal with the police, will also deal with the State Security Agency. It will also deal with what we call the interception judge. So they also report there. Sometimes they even call the Auditor General of South Africa to come there. That's why they could join instead of just a portfolio committee.
So it's a joint committee, not just a portfolio committee.
I think it's just semantics.
It performs the same function as a portfolio committee, but it under it various departments.
Departments, yes,
fall. Yeah.
And then it is the only committee of Parliament that conducts its business behind closed doors.
Mm-hmm.
I think that's the one significant difference.
Now, you've said that you are responsible or accountable as IGI to the Joint Standing Committee on Intelligence, and not to any other instance. I presume that includes the Minister.
That is correct.
But in your evidence, and certainly in the submissions and summaries we will put before you, Chair, we will show that the legislation is far from clear. and there are anomalies in the legislation, and certainly in the way the legislation is interpreted and applied, that blur the lines of accountability, blur at the very least. Am I correct in that observation? And we will deal with that in due course.
That is correct, Chairperson.
And one of the considerations in relation to independent oversight is to look at the legislation, and we will address you and a report in due course in that regard, Chair. But in paragraph 9, you deal with the details of your appointment, and you've told the Chair of that. You say you were appointed by the President, and the National Assembly passed the resolution for your appointment on the 29th of November 2016.
That is correct, Chairperson.
And you say it was passed by significantly more than the two-thirds majority required by the Constitution. Is that correct?
That is correct, Chairperson.
And the implications of the requirement that Parliament, by two-thirds majority, must approve your appointment are clear. Your appointment is at the highest level, the Executive and Parliament.
That is correct, Chairperson. I think that one can also even draw a comparison between the Inspector General of Intelligence and the Public Protector. The other one will be a simple majority, I think, 50+1. This one is a two-thirds.
Right, and then you say, and you'll deal with this in more detail later, in the last sentence of paragraph 9, what the position was preceding your appointment.
That office did not have the Inspector General of Intelligence for a period of 22 months. This was occasioned by this voting. So there were interviews, 2 interviews, if my memory serves me well, and in each case, the interviewing panel, which is actually parliamentarians, the members of the committee, would have recommended somebody, but every time they went to the National Assembly, they could not garner a necessary majority. So, you know, it will then fall by its wayside, and then the second one came again until I got appointed. But for 22 months, my predecessor had left that particular office.
Right. Is that a good thing, a bad thing?
It is not only a bad thing, it is actually a dangerous thing, because I mean, even if you are reading literature, sometimes you will really struggle to fathom what the intelligence services are doing, not even in our jurisdiction, but you cannot really sit with intelligence services that go unchecked. If certain things even happened in this country, in the existence of the Inspector General of Intelligence, or the office itself at least, you would then realize how important the existence of such office is, and how dangerous it can actually be if they go unchecked. Because this office, Honorable Chair, it then it becomes like IPID, but only, I sometimes say, in a simplified manner, one can say that it is the public protector of the intelligence services. Because if you look at what we do, like we investigate maladministration, corruption, compliance with the Constitution, compliance with applicable legislation, and so forth. So if you look at our functions, it's only that we are doing that, but then it means that the existence of the OIGI may sort of, bring about a situation where these other institutions cannot come and do oversight over the intelligence services themselves. There was a reason for that, obviously. We wanted to keep it, still, under the veil of secrecy.
So prior to 29 November 2016, for 22 months, the office of the Inspector General of Intelligence was vacant.
That's correct.
And it's worth mentioning, Chair, that at least some, if not much, of the evidence given covers that period, given by the State Security Agency witnesses.
May I please also maybe mention to the chairperson to say that we need to say what exacerbated the situation. It's what you say will be advocate will be dealing with later, which talks about how the legislation, the Oversight Act is drafted. Now, the legislation does not create an office. It does not say Office of the Inspector General of Intelligence. I'm only using this word. You cannot find it there. It talks about IGI, and it becomes this particular person. In the absence of that person, no one else in the office can do the work, because then it gives me the powers also to then delegate my powers. So in the absence of that delegation, I thought maybe I should just mention that point. Yeah.
Paragraph 10, you've already told the chair that your mandate is to conduct intelligence oversight on all statutory intelligence services, crime intelligence of the South African Police, defence intelligence of the South African National Defence Force, and now the State Security Agency. Is that correct?
That is correct, Chairperson.
Paragraph 11, you deal with Section 7 of the Oversight Act, which sets out what you state in paragraph 11 to be your accountability and mandate. 7.6 says, the Inspector General shall be accountable to the committee for the overall functioning of his or her office and shall report on his or her activities and the performance of his or her functions to the committee at least once a year. I take it that that committee is the Joint Standing Committee of Intelligence.
That is correct, Chairperson.
And then 7A, what does that provide? Section 7A.
It is 77A.
Yes, 77A.
It talks about the monitoring of compliance by any service with the Constitution, applicable laws, and relevant policies on intelligence and counterintelligence.
Right. And those policies what are those policies? Just name one or other of them, please.
It includes their own policies, and in this instance, one can mention what they call the MPDs.
Right. Internal policies.
Yeah, even that your own internal policies. Yes. It could be a policy on recruitment, for instance.
What about the white paper? Would that be a policy which you would monitor compliance with?
That's correct, Chairperson. We can also monitor compliance with that.
While we are on the white paper, in your view, what is the status of that white paper? There's been commentary by a number of witnesses who have, to put it at its lowest, different perspectives on the status of the white paper. What is your evidence in that regard?
My evidence is that the legislation, including the Constitution, mirrors exactly what is contained in the white paper. In fact, any deviation from that will be problematic because it was a policy document where they sat down and they said that this is how we want, the intelligence services to be configured, and these are the powers that you would like. So all those other pieces of legislation, such as the Strategic Intelligence Act, such as the Intelligence Services Act, such as the Oversight Act itself, are sort of coming out of the white paper. So our position and the legal advice that I have from my office is that it should not be ignored, and non-compliance with the white paper, we can, as an office, make some findings and recommendations on it.
Right.
Well, you need to make use of the white paper where, as you put it, its contents or principles are already mirrored in the Constitution or legislation? Because I would have thought that once that has been done, you must just comply with the Constitution and the legislation.
Our position and maybe my submission also to the high-level review panel was to say that it should not, belong to the dustbin of history, especially in instances where you will have a lacune in the current legislation. For instance, one of the biggest issues that happened was the amalgamation of the then National Intelligence Agency and the then SARS, South African Secret Service. And it just happened by a proclamation. So the current Strategic Intelligence Act may not have been sufficient to deal with how those different services could be amalgamated or even disentangled as they're intending to do it now. That is my position, Chairperson. It's not a legal argument.
Yes, okay, all right.
What does 77C say? I'm sorry, Chair.
I'm sorry. What you didn't tell me about, maybe it wasn't important, but now that you tell me about legal advice, is your own background legal background or not?
No. I'm qualified in forensic investigation.
Oh, okay, all right. So you have to depend on legal advisors.
Yes.
Okay, all right. Thank you, Mr.
Section 77C of the Oversight Act, what does that provide?
It says that I shall also perform all functions designated to me by the President or any minister responsible for a service.
How do you interpret that in relation to your duties to investigate from an independent standpoint?
We are calling them a tasking, so which means that the minister will, for instance, have a serious problem with, let's say, absenteeism in one of the agencies. And she may just decide to say that the Inspector General, because you've got the investigative powers, please investigate this particular matter. But it's not like they really supervise me, instruct and supervise me. I think that's where we are struggling to draw a difference, and the ministers are also struggling to draw a difference. They think that for me to perform designated functions, it's like they can, just tell me what to do and supervise me throughout there. So the outcome here will be an independent outcome. And unfortunately, if the president likes it, or if he doesn't like it, it's something else.
And then subparagraph CA of section 77, what does that provide?
I then receive and investigate complaints from members of the public and members of the services. In other words, the three services that we've mentioned earlier, on the following: alleged maladministration, abuse of power, transgressions of the Constitution, laws, and policies referred to in paragraph A.
And then sub D of 77?
Oh, then, I'm sorry about that. I think that I left out a very important part there, which deals with also investigating any contraventions of the Prevention and Combating of Corrupt Activities Act.
Right. And the improper enrichment of any person through an act or omission of any member. That
is
would be
correct.
a member of the security services. Right.
But from the public as well, very much important.
And as I understand how you read the provisions of the Act in relation to your independent oversight function, that you may be requested or designated the function of conducting an investigation, but in the conduct of the investigation, that is your business as an independent oversight body.
That is correct, Chairperson.
And then sub D, what does that provide?
All right. Now, all these functions which are contained in 77, I normally summarize them to say more in. We do monitoring, we do review, and then we also investigate complaints. Now, at the end of a financial year, they all culminate into what we will then call a certificate. Certificate, they use that word in the Oversight Act, but it's more like an annual report where I then, summarize, I would have done monitoring there are problems there will be a review, there are problems there, it will be investigation of complaints and so forth. And then I submit that certificate firstly to the ministers, responsible ministers, and then I later go to the Joint Standing Committee on Intelligence to make a presentation on my findings and recommendations as they are contained in that. It's normally a lengthy document, around 60, 70 pages or so.
Yes, and
That's
sub
the-
E and
sorry.
sub F over the page.
Sorry, Mr. Pretorius, the document you are talking about is the document that is called certificate.
Yes, in terms of the Oversight Act, they refer to it in 11C as certificate.
Okay, so when you talk about a certificate in your affidavit, I mustn't have in mind a one-page document like a certificate. It's a lengthy document. It's in effect, as you say, an annual report.
It is like an annual report, but we are raising a very important issue. So I will have like a one-pager.
Yes.
We even, print it in colors and so forth.
Yeah.
And in there, I will say that I express an opinion on whether anything done by the intelligence services was in contravention of the law or the constitution or their own internal policies. So I will write that, but this certificate, which is a one-pager, it is always accompanied by an annexure. So we will call it an annexure. But it will be a narrative report because in a one-page I will say that I'm not satisfied with this and I'm dealing with it in paragraph 18,
Yes.
A, B, and C in the annexure.
Okay.
But then we bind it. So, and you will have 3
Okay.
because we make one certificate per service.
Okay, all right. Yes, Mr. Pretorius.
And then sub E and F over the page deal with your duty to submit reports to the JSCI, to the ministers that we've mentioned, and in certain circumstances to the President.
That is correct.
Now, all these reports and certificates are a matter of record. They can be provided to the chair, but depending on decisions concerning declassification, they may not be able to be released to the public.
I know that you don't want us to deal it in a piecemeal fashion, but I've done that activity already because what I've done in terms of, they are my documents, so I've got a lot of powers to really declassify. What I've done is that I've redacted all the information which deals with organizational weaknesses, which deals with their methods of the intelligence, as well as what they call sources or informers, if you like. So I've already removed that kind of information because what I wanted to show the Commission is only the transactions, procurement, and all those other issues. So yes, of course, but they will be submitted.
They will be submitted to the chair in due course, suitably redacted. Then paragraph 12, 12A, is a reference to section 710 of the Oversight Act, which enjoins you to comply with all security requirements applicable to employees of the agency. Now that becomes relevant, as you will detail later, in relation to your own security classification. Is that correct?
That is correct,
Security
Chairperson.
clearance.
That is correct, Chairperson.
And we will deal with that in due course. And also some anomalies that arise out of that process and who performs that process. Then sub B says, shall serve impartially and independently and perform his or her functions in good faith and without fear, favor, bias or prejudice. Now, those are fine words. What import do they have for your work?
Is that the independence is guaranteed, and it is even in legislation. So I think that as we go deeper into my evidence, I'll want to portray to the Commission how that independence has been undermined to an extent that one day will be asked the question, where were you when things were getting so awry?
Right.
Well, well, I must say that I was already asking those questions when I was hearing a lot of SASA evidence, or not SASA, SSA evidence. So where was the Inspector General? But you are here now to tell me where you were.
Yes, Chairperson.
Okay.
And I'm not going to justify anything. I'm going to admit to the failures.
Yes,
Okay.
we will get there.
We will get there, yeah.
Chair, and then in relation to the manner in which the Constitutional Court has described the requisite independence of an oversight body, you refer to the Glenister case. It's referenced there. If I can just read the last 3 or 4 sentences or lines of that paragraph, where the court held that independence in this context therefore means the ability to function effectively without any undue influence. It is this autonomy that is an important factor which will affect the performance of the anti-corruption agency. Now, that decision was made in relation to the Directorate for Priority Crime Investigation, or the Hawks. But do you say, or are you submitting to the Chair, that that applies with equal force to your office?
That is our submission, Chairperson.
Has that prescript, in your experience, always been followed?
No, not in all instances.
And then references made to the McBride case, and the decision is referred to in paragraph 15, where you deal with the question of the independence of IPID, but are you saying to the Chair that similar principles apply in your case?
That is our submission, Chairperson.
Particularly in regard to appointment and removal of the incumbent of the post.
That is correct, Chairperson.
And very importantly, in paragraph 16, you note that in both Glenister and McBride, the Constitutional Court held that the public perception of the independence of the institution is an integral feature of its actual independence. This requires that a reasonably informed and reasonable member of the public will have confidence in an entity's autonomous protection and oversight capabilities. I may just intervene there. There may be a reasonable suspicion that we drafted this on your behalf. Is that correct?
Yeah, but I did draft that.
You drafted
Chairperson, yes. Independently, so.
Independently.
I like the way you put it, Mr. Pretorius. Legitimate suspicion, a reasonable suspicion.
Legitimate expectation, which is not met in this case.
All right, Chairperson, you may have asked me earlier, my qualification is not a law degree.
Yeah.
I did what they called Bachelor of Criminal Justice.
Yes.
That was my junior degree.
Okay.
And then I ventured into like your forensics when I got to master. So
Yes.
It had a lot of law modules.
Yes.
We're even falling under School of Law.
Okay, okay.
Yes.
No, that's fine.
So these are your submissions.
So these are my submissions.
And then in paragraph 17, you say the Inspector General of Intelligence should be accountable through the Joint Standing Committee of Intelligence to the legislature alone. It is constituted, the JSCI is constituted by a proportional representation of political parties. It is therefore designed to represent the interests of the people more broadly than the government of the day. But again, your submission.
That is also my submission. That's correct, Chairperson.
Right. You trace some of the history of executive members relevant to state security in paragraph 18 and following. Would you deal with those just briefly? Just name the officials, please, and say when they held office.
I will do that, and I'm going to be very brief, Chairperson. In 1994, there was no Minister of State Security. they were subordinated, they use that word, they were subordinated to the Minister of Justice. So you will have this big Ministry of Justice, and then you will have a Deputy Minister. And at that time, it was Minister, the late Joan Hlanhla, who became the Deputy Minister of Justice, but with responsibility of the intelligence affairs. In 2000, the ministry was established, and it was led by ministers. I will just mention a name and the years. Lindiwe Sisulu from 2000 to 2004, and it also had Minister Ronnie Castellers from 2004 to 2008, followed by Minister Siyabonga Cwele, 2008 to 2014, and then later Minister David Mahlobo from 2014 to 2017, and then also followed by Advocate Bongani Bongo, who was there only until February 2019. I think it was a period of 2 months. And then he was followed by Minister Letsatsi Duba, and then followed from May 2019 by Minister Ayanda Tlotlo, who is still the incumbent now.
Right. And in relation to the Office of the IGI, paragraph 22.
Yeah, we start this a little bit earlier in 2004, but there will be some other arrangements that happened before that. I didn't think that they will be so much relevant. But one of my predecessors was Mr. Zolani Ngakani, who was appointed as the IGI in 2004, and he remained in office until December 2009. The position was vacant from December 2009 to April 2010, when the late Ambassador Faith Khadebe took over. And then she held that position for 5 years until 2015, until I joined that office 22 months later, which then will be 2017.
Right. And you make the remark in the last sentence of paragraph 22 that it has not been in the interest of the public that so vital an oversight post has remained vacant for extended periods.
That's correct.
You confirm that. Right, then this is reasonably important in relation to the history of your engagement with the Commission. The provisions of Section 7(8)(a) and (b) of the Oversight Act provide that the Inspector General shall have access to any intelligence, information or premises under the control of any of the intelligence services, if such access to any intelligence, information or premises is required by the Inspector General for the performance of his or her functions, and he shall be entitled to demand from the head of the service in question and its employees such intelligence, information, reports and explanations as the Inspector General may deem necessary for the performance of his or her functions. And if we can just complete that before you answer any questions in that regard. Paragraph 24, you refer to Section 7(9). Access to intelligence, information or premises contemplated in subsection 8A may not be withheld from the Inspector General on any ground. Now, we will deal towards the end of your evidence in relation to events that have happened in the past month or so, subsequent to the testimony of the witnesses in January of this year before the Commission. But very briefly, what is the import of these sections?
The import of that section, I will say that it will be twofold. The first one is to ensure that this office is never ever denied any information. In fact, Chairperson, they even make it a criminal offense to do that. Because intelligence services, by their own nature, are secretive in nature. It's an acceptable principle worldwide. So here, they wanted this particular office which will have an unfettered access to intelligence because things will get hidden. But the second point there is that all right. The second point is that it shows that the Inspector General of Intelligence it says there, may deem necessary for the performance of his or her functions. It was also, in our view, trying to, prevent a situation that I was telling the chairperson about earlier here. An instance where you will get the other functionary who will want to take the discretion as well as the powers of this particular office. So in other words, I do have a right to even meet with the people from the commission, people from the Hawks, if you like, or even people from IPIT, and be able to deal with that information or the access to information there.
Right. It's important that the information to which you're entitled in terms of the Act is that which you deem necessary, not anybody else.
That is correct.
But it's also important that it is stated in two senses. You're entitled to the information, and nobody may refuse to give you that information, as I understand the position, on any ground.
That is correct.
And failure to comply with Section 7.8, that is in relation to your access to intelligence and premises and the like, is an offence, as you've pointed out.
That is an offence. That's correct, Chairperson.
And then in paragraph 26, you mention one of the requirements which will become relevant later, preceding the appointment of an Inspector General of Intelligence. What is that?
That is what they call a security clearance. So you'll be vetted. You'll undergo this process of being vetted. And the requirement there is that I should be cleared at a level of secret, top secret, in fact. In other words, that provision means that I may be recommended by Parliament, get appointed by the President, but if I fail this requirement, I will not occupy the position of Inspector General of Intelligence.
Right. Now, in paragraph 27, you deal with how you understand oversight, and it may be a matter of controversy, and is indeed a matter of controversy, but how do you interpret and apply the legislative framework which provides for your oversight function?
Yes, it remains a debatable issue in terms of what oversight is and so forth. And I had those engagements with the first person that I worked on the affidavit, here, because he was saying that, but the constitutional provision talks about monitoring of the intelligence services. And my position is that, in fact, the word oversight is all encompassing, because it includes monitoring, it includes review, it also includes investigation of complaints. The other people feel that the word monitoring and review may also be semantics. We don't think so. We think that monitoring can happen simultaneously with whatever. So if I want to make an example which is not controversial again here. If the State Security Agency says that we want to recruit some students so that they can be employed permanently, I can even go to those interviews. I can be involved in the selection process and the shortlists and so forth. So we see that with monitoring. Whereas review may happen in hindsight when the whole process has been completed and you are able to really look into that. But our take is that oversight really encompasses all these activities that we are doing.
In paragraph 28, you state what the provisions are that govern the intelligence services, as well as the Office of the IGI. You mention the Constitution and the Oversight Act. You also mention policy documents which contain checks and balances, which include the White Paper on Intelligence and the Minimum Information Security Standards, the MIS document to which the Chair referred earlier, and other aspects of the regulatory framework, regulations, directives, policies, and standard operating procedures. All those constitute the governing framework of the intelligence agencies. Am I correct?
That is correct, Chairperson.
Right. In the case of the SSA, the lack of effective checks and balances was listed as one of the cardinal reasons for the alleged malfeasance, corruption, and fraud perpetrated at SSA. That's your statement in paragraph 29.
I confirm that's my statement.
And that state of affairs apparently led to the establishment of the high-level review panel chaired by Dr. Mufamadi, which we've spoken about here and we'll speak more about in due course, but evidence has been led in that regard. Is that correct?
That is correct, Chairperson.
And we'll deal in due course with the findings of not only that panel, but also of two preceding inquiries. Can you name those, please?
There was what we call the Matthew report. I would like you to, it's a long name, I would like you to direct me to, there's a paragraph.
We'll deal with it in due course. The
Yes,
Matthews
later,
Commission report.
Chairperson, yeah. It's a long name, it's two different panels.
Okay.
And the second one was a panel that sat during 2006, am I correct?
That's correct. No, the first one was 2006, the second one is 2008.
And they made very clear findings in regard to the Office of the Inspector General of Intelligence, and in particular its independent functioning.
That is correct.
And we will highlight those in due course, Chair. Paragraph 30. What was the question? You can read it if you wish to the Chair. That was posed by the high-level review panel.
That's exactly, Chairperson,
you
where I
seek to
said,
address.
oh, sorry. That's exactly where I was saying that there could be questions, maybe by the next generation even, who says that where was the oversight when this was happening? And
The questions may come sooner than the next generation.
oh, okay. Yeah. So my submission to the Commission followed. It was followed by the particular phrase which said, "The framers of our Constitution and democratic intelligence policy and legislation created an oversight system for our intelligence service comparable to the best in the world, comprising a bicameral, multi-party parliamentary committee, the JSCI and the IGI. The question is, given the abuses and infractions identified in this report, did these oversight mechanisms function effectively? And if not, why not?"
And then paragraph 31, what is your contention in this regard?
My contention is
very
that
generally stated.
Okay. My contention is that if the OIGI was strengthened, Chairperson, there was not even a need for the HLRP, for the high level, for the what we call a Mufamadi panel, because then we would have been able to, deal with all that work. I mean, if you look at what the Oversight Act says we can do, I think it's a lot. I mean, if we deal with the prevention of the Combating of the Corruption Activities Act, if we deal with maladministration, abuse of power, and all those other issues. That's exactly the reasons that led to the establishment of the high-level review panel.
Yes, you say in paragraph 31 that had the OIGI been sufficiently strengthened, what would you say to the proposition that it had all the powers? It had access to premises, it had access to documentation. No one could refuse that. How did it occur? I think we'll get into it in more detail, but perhaps you can begin to address the question. How could it happen that what appears to be a vast amount of fraud and corruption occurred within the State Security Agency?
Sorry. The first basic reason will obviously be that after the period or the tenure of Mr. Nakani, it remained vacant. And after the period of my predecessor, Advocate Khadebe, it remained again vacant for 22 months. But the strengthening, we will deal with that. I think that what I can say at this stage is that we are not an intelligence outfit. There is a colleague of mine here who's accompanying me. He will tell me if I shouldn't disclose this. But we are working nationally, Chairperson, and my staff complement is only 34 people. We do not even have a satellite office, provincial office whatsoever. I don't think that that is a sign of a strength of an institution which has to deal with such a cumbersome work of overseeing the intelligence service.
There is the issue of capacity.
There is a big issue of capacity, Chairperson, lack of independence,
Yeah.
but also the vacancy.
Yeah. There are vacancies which are not filled.
There are vacancies that are not filled. Out of that 34, I'm sitting with only 24 people.
Yes.
Some of them are only doing administrative work,
Yes.
and they are not really investigators.
But has there been an exercise done which seeks to answer the question, how many staff should it have, should this office have, if it is to realistically and effectively do its job? Has there been that kind of exercise, and is there a report that has been furnished to those who control the purse and those who can do whatever is necessary to say, look, if you want this office to be effective, at least the minimum in terms of staffing the requirements, this is the minimum. And 34 is way below that or anything like that, or has that exercise not been done?
We have done that many a times, Chairperson. When I assumed my position, I also developed what we call 2022 vision. It was a 5-year strategy of that particular office. And we came up with a structure that we then submitted together with what we called a concept document. Now, in a concept document, because we do not have legislative powers, legislation-making powers, we will normally advise the Joint Standing Committee on Intelligence that we are sitting here and we have a practical experience of how this legislation works. So we would have written to them. I know this, the legal team always loves this off. When I mean not off, they really get surprised when I tell them that the Inspector General of Intelligence does not have the appointing powers. The legislation says the Minister of State Security shall appoint people to the office of the Inspector General of Intelligence. It has never happened since I got there. People have gone on retirement, some have resigned, and so forth. No one, there's no one, not even a single person who was appointed for the past 4 years that I was in this office, which makes a perfect sense. I mean, if I was a minister myself, I wouldn't appoint people to go to an office which will keep on pestering with me, I mean, as an institution.
Yes, but of course, that has to be wrong, because if legislation says there must be the office of the Inspector General of Intelligence, or there must be the Inspector General of Intelligence to perform the following functions. If those functions can't be effectively performed by the Inspector General of Intelligence without other people or professionals, then you are rendering the office ineffective if you know that there are vacancies and nothing is done to fill those vacancies. And if you have, I guess it would be difficult to say appointments are not being made because we have no money. Because how then do you expect the office to perform if already there has been a determination that at least there is justification for there to be 84 posts? It's different if that determination has not been made.
Chairperson, later I quote a paragraph from one of the letters from the Director General of the SSA, then the
Yes.
former one. And I address exactly that issue. I take out a paragraph where he writes to me to say that we cannot fill those positions.
Yes.
And what exacerbates this state of affairs is that there are funded positions, at least in the minimum. So this will be the people who would have left, went on retirement or resigned or got transferred, for instance. So even if you do not then change the structure of 34, at least let's deal with the funded positions. When the funded positions are there, the money will always be there.
Yes, yes.
Yes. Issues of the strength of the office of the IGI, which you've mentioned in paragraph 31, its independence and its capacity to function effectively, you deal with in the following paragraphs. But an illustrative example is your budget. Who and how is your budget determined? Who determines your budget? How is it determined?
All right. The Oversight Act says that the budget of the Inspector General of Intelligence shall be appropriated through the vote of the Ministry of State Security, which is not a problem. I really don't have a problem with that because we don't necessarily need to have a vote. What we have a problem with is that there is no prior determination that is made before the money reaches the state security agency. So it will only be after that, after they've received, let's say they give them 8,000 rand. Now I have to go there and beg as if I'm one of the chief directorates there. Their college, the other department chief directorate, what they will say that our requirements or our needs are standing at about 130 rand, you know. So I also come there and the director general then determines whether he's going to give me what I've requested. Chairperson, I was never ever given what I would have requested. So there will be a particular baseline and they will always give me that money.
But the point about that is that the very body and office over which you have oversight, the SSA is the very body whom you have to deal with in obtaining your budget. Is that correct?
That is correct.
Yeah, probably, maybe that's the issue because otherwise everyone who has to ask somebody in government for money will tell you they never get given what they want. You know, where even with government departments, ministers will always complain, you know, that the Minister of Finance won't give you what you want. You know, you come and say, this is what I want, and you think you have motivated sufficiently, but they'll always, or very often, you'll get it less. But it's important that whoever makes that decision must be somebody who can be taken into account only legitimate factors in deciding. But your point might be that what you would prefer is that the money that should be used by IGI should be ring-fenced by Parliament, even if it is under SSA or whoever, but you shouldn't be talking to somebody about how much it should be. Parliament should ring-fence it and say, this is for IGI, and then you should be able to use it for the operations of your office. And if somebody has to account for it other than yourself, then it must at least be finishing whatever needs to be finished, but Parliament should be the ones who say, Parliament should be able to say, out of this budget for SSA, if it is SSA, so much is for IGI and can't be touched by somebody else. Is that what you are talking about, or not really?
I was asked that question,
Yes.
by the committee when I was asking for that intervention.
Yes,
And
yes.
they misunderstood initially.
Yes.
Me to mean that I want to be given above all these other departments. And that was not my contention. Now, this is how we are where we are at now. In 2016, 2017, the head of corporate services in my office writes to the DG of SSA and say that you've been giving us this budget, but for 2016 and early 2017, we do not have an inspector general. So we will not be able to use that particular money. So they only said that you, in the meantime, just give us money so that we can pay for rent, lights, personnel, cost and so forth. So the money was reduced at that particular point. When I started in 2017, it was already a beginning of a new financial year. And I nicely went back to them and said that, but this was the baseline. So they would have removed a lot of money. Now, they wanted me to start again where they would have, put that particular amount. In other words, I started with a budget which did not include the operations of a fully functional office now, because I had taken incumbency there. And that has always been my argument. My argument is never to say that I know that even SSA themselves, their budget has been cut over and over again, I think 2 consecutive years now. All the other departments, I understand all the pressures of the fiscals. All what I'm saying is that if my baseline was standing at 1,000 rand, and somebody in my office, rightly so, came and said that don't give me 1,000 this year because I'm not going to be able to, give me 500 rand. You cannot expect that then I started 500 and I start moving at a cost of about 4 or 5%, because that's what they do just to cater for the personnel expenditure and for the increments and so forth. So you cannot expect me to do that, to start there again and start building a new baseline. That is my complaint.
So your complaint is that there's a certain baseline that was determined at a certain stage. There may have been a valid reason to go below that at a certain stage when there was no IGI. But once you had been appointed, should have gone back to the baseline.
That's correct, Chairperson.
Yeah. You're not complaining about wanting it to be ring-fenced or anything. That's not your...
Oh, no, by the way, Chairperson, maybe I should have mentioned that we managed to get ring-fencing. But it is done by Treasury.
Oh, that's achieved.
Yes,
that's been achieved.
it is achieved. The only problem is that it is done after the money has been given to the State Security Agency.
Yes.
Reinstatement should happen on the other side, because this model works perfectly with public protector who are getting their budget, I think, through Justice and Constitutional Development. You have IEC who are getting from Home Affairs. So they never really have, I think NPA is also getting from somewhere. But during the appropriation in Parliament, they already make a determination that this amount belongs to, IPIT is a good example. This amount belongs to IPIT.
So that has not been done in regard to IGI.
That's correct, Chairperson.
The ring fencing happens after Parliament has appropriated. So the ring fencing gets done by SSA.
By SSA, yes.
And your point is it should be done by Parliament just as it is done in regard to the public protector and other institutions.
That's correct, Chairperson.
Okay.
Right. Just so the point is not lost then, we were talking about it earlier. You monitor the SSA and call the SSA to account.
That's correct.
Is it appropriate in your view that that instance which you have the duty to monitor has a hand in determining your budget?
It is not it's not right at all, because it undermines independence. But again, you are sitting with these people that you are basically dependent on them.
And then you raised another point in relation to the budgetary situation. What do crime intelligence and defense intelligence think about your relationship with the SSA in relation to your budget?
Yeah. And
They've
maybe
expressed
let's call it a third-party dependence, Chairperson, because I'm sitting in the premises of the ministry administered. I'm sitting on the server of the State Security Agency. And the complaint by by management of crime intelligence may not be current, as well as the defense, is that in this instance, we have a counterintelligence mandate to protect our own information. So you are sitting there on the ICT infrastructure of the SSA. In other words, their beef is that SSA could have an upper hand as far as that information is concerned. Because I collect the information, I go to my office, but I'm in the same premises. I mean, they can open those premises. They are providing security there and everything. So that is the complaint as it comes from the other services, intelligence services.
Okay, all right. Let's take a 10 minutes adjournment, or do you want to ask one more
Just
question?
one question,
Yeah.
if I may, so that
Okay.
we don't overlook it. I might overlook it, Chair. Is it correct that your information, your digital information, is on the server of the SSA?
That is correct.
Is that appropriate?
No, it's not appropriate.
So if you receive a complaint from a member of the public about SSA or members of the SSA, once it's in your system, they can access it?
Yes, I mean, yeah, I think digital people will also tell you that there's always, I mean, if I own the infrastructure, it is my infrastructure.
Yes,
It doesn't even need like special skills.
Yes.
I think that if you look at it from an employer's point of view, is that always I will have a right to
Yeah.
access the systems
Yeah.
of other people just
Yeah.
to check few things.
Yes.
Yes.
Okay, let's take a 10 minutes adjournment, and then we'll continue after that. I think we'll come back at 4:15 or so. We adjourn. Okay, let's continue.
Thank you, Chair. In the context of the independence of the Inspector General of Intelligence and his or her office, we're dealing with two aspects in your statement. The first is issues of the structure of the office, the context within which it operates, and certain administrative matters like the budget and other operational matters. We will get in a moment to the conduct of the SSA in your experience. That's a separate and second issue affecting the independence of the OIGI. In paragraph 32, you summarize it aptly. I think, would you care to read that paragraph onto the record?
I say there, Chairperson, that the OIGI has, since its establishment, been dependent upon the Ministry of State Security and the SSA for its operational needs. Operational needs include, but are not limited to, the expenditure in brackets budget, which is allocated to the OIGI by the SSA, the payment of the personnel necessary to perform its mandate, the information and communication technology or ICT made available to it, the office space allocated to it, and other tools needed for the functioning of the OIGI. This has led to a third-party dependence that undermines the required independence of the OIGI and impinges upon its ability to effectively discharge its mandate. This is because the OIGI is both beholden to, in terms of the operational needs of the OIGI, and responsible for the auditing of the SSA, and when necessary, the Minister of State Security. This is further demonstrated in the other paragraphs.
Then in paragraphs 33 to 35, you deal with the classification of the Office of the Inspector General of Intelligence in terms of the Public Service Act. And in summary, and we needn't go into detail, in summary, what you're arguing for here is that the Office of the Inspector General of Intelligence should not fall within the SSA administratively or operationally. It should be a separate entity in terms of the Public Service Act. Do I understand your argument correctly?
You understand my argument correctly, Chairperson. I further submit that that its form is unknown. That's the term that they use. Like they will tell you that you don't know what is this institution. Is it a statutory body? Is it a constitutional body? Is it a government department? You'll have national department. Is it a provincial department? And that's exactly what the Public Service Act does when they talk about the scheduling of different institutions of government.
So as I understand what you say, and of course there may be other explanations or excuses or whatever, the SSA doesn't say to you, you can have your own server. It says use our server.
That is correct. And Chairperson, each time you ask them, because I am a Fikizol, I only came yesterday. But obviously there will be history, attached to that. So I kept on asking them, which legal framework was used to put this office here? And you never ever get that answer. Because the Oversight Act does not say anything about an administrative connection between the OIGI and any of the intelligence services, not even the SSA itself. So there is nothing in legislation which provides for that.
Right. And then in paragraph 35, second sentence, you make the point that we mentioned just before the short adjournment, where you say, in reality, however, the SSA and its Director General in particular holds the administrative power and the purse strings over the OIGI, its own oversight body.
That is correct.
That is the resultant outcome of the structure that you operate under. Is that correct?
That is correct, Chairperson.
Then You say in paragraph 36 rather, the extant oversight powers of the OIGI have been further undermined by the conduct of the SSA and the Director General in particular. To whom are you referring there?
I'm referring to Mr. Arthur Fraser.
Well, what do you say? What is your description of those events which have led you to that conclusion in paragraph 36?
All right. It will be a plethora of issues that actually came to the fore that I actually ended up in court trying to litigate and get an interdict against Mr. Arthur Fraser. So it's plethora of them. I hope that maybe Advocate Procedural will be able to gloss through them as we go into this. May I also remark, Chairperson, if you allow me, to say that when I was working on this affidavit, I had a discussion and I said that it should not sound as a personal grievance. So every time I talk about these issues, I was trying to show how do they defeat the principle of independence, other than dealing with myself as a person at that particular point. In other words, these can also be applicable to any other incumbent at any given time. So I had that discussion, I think, with the legal team here also to say that I just don't know how to reduce these issues or to show the Commission that I am talking about how the whole office is defeated, not a person or even any of its employees.
All right. So you worked with the Director General of SSA, Arthur Fraser, during a period of your incumbency of the office of the IGI, is that correct?
That is correct, Chairperson.
And what you're going to tell the Chair later is what your opinion is of the elements of that relationship which you experienced.
That is correct. I'll be doing that, Chairperson.
Right. Let's go then to paragraph 38 and deal with the filling of vacant posts in the OIGI. Who has that power as you understand the position?
It is the Minister of State Security in consultation with the OIGI.
The Minister or the Director General?
The Minister, it's the Oversight Act says the Minister.
All right, because you say in paragraph 38, then you could explain this, because it seems somewhat different to what you've just said now. You say another crucial factor which has served to undermine the independence of the OIGI is the control the Director General of the SSA has over the filling of vacant posts in the OIGI. Is that correct, or must we qualify it?
I can qualify it. I'm not even rectifying it. That was the intended statement. Any minister will have what they call a political oversight over these institutions. So in an ideal world, they don't get to involve themselves on issues of budget, on issues of operations, and all those other issues. So by extension, although the legislation says that the minister shall appoint, when I make appointments, the person who's sitting with the money is the accounting officer, who is the Director General of the SSA. And it's a well-known fact. That's how the communication will go. I will talk to the minister and say, the minister, if it ever happened, it has never happened, unfortunately, but I will say, Minister, there are 2 vacant positions which are critical. For instance, I don't have an office manager. I literally run my own office. I never had a PA for a very long time. I got somebody somewhere in the office to do that. And then immediately after communicating that, the minister may write to the Director General and say that, please then deal with this. But the ultimate power of releasing the money, of conducting interviews and so forth resides with the accounting officer. The minister may sign as a final signatory on the submission that appoints those people. So that's why I'm saying that although you talk to the minister, but the Director General had more power In fact, even more than the minister had in terms of making those decisions.
Well, let's try and summarize the next section then.
So just, Mr. President, just to go back to whether that first sentence is correct or not, you are saying, insofar as it says the Director General of SSA has control over the filling of the position, you say that's fine and that's correct, because you are not saying he has the power to fill the position. The power to fill the position vests in the minister, but the minister, in order to fill the position, must know that there'll be money to pay those people who will be appointed, and the Director General, as the accounting officer, is the one who has got to say something about this. So if he is not in support, you will end up not having an appointment.
That is the proposition that I'm making.
Well, briefly, if you would summarize what happened in November 2017 in relation to appointments.
Yeah, now that is a good example of then who's holding the strings. I don't know if the word power, maybe we are using it both sides, but who's holding the strings? So in November 2017, I wrote a letter to the Director General. So I would have spoken to Minister Mahlobo, who said that in principle, I don't have a problem. So please tell us, give us like the list of the positions that you want filled. And then I wrote a letter to the Director General, Mr. Arthur Fraser, and I informed him about my intention to commence with the recruitment drive. In other words, asking him to facilitate that process. Although those posts were funded, I still required Mr. Fraser to release the funds in order to fill the post. Now, they will explain, like the CFOs, Chief Financial Officer will explain that the money sits somewhere because the only money that they release will be for warm bodies. So as and when the position remains vacant, the money will be somewhere, but it will not be readily available. So there it was not even asking for permission to do that, because I know that the permission was to be sought from the minister. I was informing him that I'm starting, may you please release those funds.
How important were these posts?
Critical posts, I can remember them from the top of my head. One of those is what we call OPO. Now, OPO is an oversight principal officer. They are sitting in my EXCO because they are component heads of different structures in the OIGI. So you will have an OPO who's sitting here, who's only responsible for crime intelligence. You will have the other one who's responsible for the domestic branch of the SSA, the other one for the foreign branch of the SSA, the other one for the defense. So these are senior people reporting directly to myself.
Critical posts.
That position is very much critical.
Yes.
Can I also mention maybe the IT specialist, like in my office? And majority of the complaints that I'm getting, I mentioned it because majority of the complaints that I'm getting will be like, I think that I'm being intercepted unlawfully. I don't know where is that paranoia coming from, because it's starting to sound like one. And for me, I cannot depend then on the SSA to say that let's check your systems if you have this particular person. I need to have somebody who will have the powers vested on him by the OIGI so that he can do that particular work. So that is the second post.
All right.
That is vacant. Yeah.
What
Just
was the
one
response?
second, just 1 second. I may have missed this earlier. The IGI position, at what level in terms of public service is it ranked, if it is ranked at all?
All right. And unfortunately, I have to then refer to the condition of service, because the condition of service are determined by the president and the Joint Standing Committee on Intelligence. So you will have a document where you will write, all my conditions of service are pegged at the level of a deputy minister.
Oh, okay. Okay.
Yes.
Okay.
And I think that it makes sense because I'm overseeing Director Generals.
Yes,
Yeah, with
yes.
SAPS, it will be a lower rank,
Yes.
Lieutenant General, and with the
Yes.
defense, it will also be a
Yes.
Lieutenant General.
Okay.
But SSA is a full DG.
Okay, no, that's fine.
Yes, and we'll come to that later in relation to certain events that happened during your watch as IGI. But you made an approach to Mr. Fraser in order to release funds to fill those 6 critical posts. What was his response?
May I please read it to the chairperson? It's just a paragraph. It's here. He writes to me and he says, regrettably, the State Security Agency is unable to adhere to your request for funding of the post as identified in your letter. The State Security Agency has adopted and endorsed its Strategic Development Plan, SDP Vision 2035, and as a consequence thereof, realigned its organizational structure and strategy. This process is underway and in its final stages. Once the final confirmed structure has been approved, it will inform the recruitment process as to what the priorities are in terms of filling of vacant posts. Do you see that, Chairperson?
What does that have to do with you?
Nothing at all, Chairperson. But this is my work, and this is a letter that is there, where this guy says, no, wait, you've got your own strategic, what, you are reporting somewhere, but I will not be giving you that money until I'm done with my own restructuring.
Right, you make that point as to the applicability of the strategic development plan to your office later on. But what do you say about Section 712 of the Oversight Act in paragraph 41?
I'm saying that there is a serious misconception of that particular section because that section empowers the minister, and I have to correct this, Chairperson, I would have said in consultation. It's not in consultation with myself. The appointment by the minister is after. That's what the Act says. It's a fine line also. But there was a misconception because Section 712 of the Oversight Act empowers the minister after consultation with the Inspector General to appoint such number of employees to the OIGI as may be necessary for the performance of the function of that office, and that is basically my emphasis. But again, we are trying to draw that distinction, I think, that we talked about, to say that who's holding the power and who's holding the real power in this particular instance.
So you refer to the power or duty to determine the needs of your office and the personnel necessary to discharge its mandate. Who in the first instance should decide that, in your view?
It is the Inspector General, the incumbent, who have to decide on that.
And does in your
because,
view...
oh, sorry, Advocate, because there is a radar there which says that as may be necessary for the performance of the functions of that office. Now, the minister is supposedly sitting somewhere.
Yes, you
He's
know
not
the
aware.
operational requirements
Exactly,
of the
it's
office.
not aware. I'm the one who knows that. But that provision also does not say that she has to make that determination. It only says that we'll appoint after consultation with myself.
Right. Does the Director General of the SSA, in your opinion, and on your understanding of the law, have any power or authority over the process of appointment of employees and the substantive decisions in relation to that appointment process?
Not at all, Chairperson.
Right. And then you make the point in paragraph 43 in relation to the strategic development plan, which was cited by Mr. Fraser as being a reason not to, or to delay the appointment, not to appoint or to delay the appointments that you required. Is it correct that you, as the Office of the Inspector General, have your own Vision 2022, as you refer to it?
That is correct, Honorable Chair.
Is your office in any way subordinated to the strategic development plan of the SSA?
Not at all. It doesn't even affect the members who are sitting in the OIGI. Even if there is a restructuring, they will never ever come closer to them.
Right. And you
Because they are not even appointed in terms of the same legislation. Staff in my office are appointed in terms of the Oversight Act, whereas they use Intelligence Services Act to appoint members of the SSA.
Right. And let's put it at its mildest. You use strong language here, but in your view, is it appropriate that the head of an intelligence service over which you have oversight and service which must account to you to determine how you should recruit staff or when you should recruit staff?
I prefer to call it rationale.
Okay.
Yes.
Yeah. Not in a legal sense, but
And how does it affect your independence?
yes, because I can't find a reason. I can't fathom the reason. That's why I'm saying that it's unreasonable. It's
Yeah.
wrong for all reasons.
Yeah.
And you say in paragraph 44, by way of summary and conclusion, so long as the budgetary allocation of the OIGI remains within the purview of the SSA, these lines of control over the functioning of the OIGI will remain blurred, providing further evidence that it is inimical to the interest, mandate and independence of the OIGI that it be subsumed under the office of the SSA.
That's correct, Chairperson.
Is that your view?
That is my view.
In this context, the independence of the office of the IGI is confirmed and guaranteed in terms of the legislation, the governing legislative framework, in fact, including the Constitution. Correct.
That is correct.
The question may arise, and it is illustrative of a view that notwithstanding the existence of an oversight body, there are matters that are so sensitive that secrecy must be preserved at all costs. In other words, there's some documents that you shouldn't have. There's some things that you shouldn't know, that should not get into any private hands. What do you say about that?
I'll request, Chairperson, that the question be repeated. I think I missed something.
Well, there may be a view, hasn't been expressed as such, but almost as such, that there's certain matters that fall within state security that are so sensitive that they should remain secret at all costs and should never be revealed outside the purview of the SSA. And that it follows that you shouldn't have access to certain information.
Yes, we have several examples to show that even written letters to the effect that you cannot have information with regard to this particular issue. Say yes, of course, there will be that continuous resistance. They are very clever. We call it managed access because they know it's a criminal offense. So you will request this document 3 times, and by the 4th time, when you want to cross the street and go to Harrisfontein Police Station, they will give that document to yourself. But it will be after many attempts, so it defeats the efficiency of this office. So yes, of course.
Yes, you've referred to the provisions of the Oversight Act, which say very clearly that you must have access to all information, premises, and the like, and it can't be refused on any ground, provided it's within, it's deemed by you to be part of your function.
That's correct, Chairperson.
Have those provisions been followed uniformly and consistently in your experience?
No, not at all. Not in all cases. That's what I wanted to say.
Right. In paragraphs 45 to 48, you deal with the budgetary issues. We have dealt with those in questions and answers today already. Do you need to expand on anything there? Can we move on?
No, not really. I think, Chairperson, I've made my point there.
Right. You have, under the head recommendations, made certain comments in paragraph 49. Would you share those with the Chair, please?
Yes, I'm making recommendations to say that there are problems with the Oversight Act. And the previous JSCI and the current one asked me previously to say that I should share with them what I think need to be dealt with. But there was another process that was taking place in Parliament to address two issues, specific issues, with regard to all oversight bodies. The first one was the funding, because almost everyone in the oversight was not happy about the funding. To say that, how do they remove it from the administrative departments so that there are no problems. But the second one was, we were informed that there is a committee that they use the word plowing, that is plowing through all the legislations. And an explanation that was given was that the researchers in Parliament realized that some of the acts of Parliament were passed like in a rush, immediately after 1994. So they said that a lot of them needed to be revisited. The recommendations that I'm making there are with regard to the Oversight Act. And I'm making two distinct ones there, if you allow me to continue.
In paragraph 49.
49.1
Yes,
and
please.
49.2. Yes. 49.1, I say the Public Service Act needs to incorporate the OIGI as a national department distinct from the SSA. And secondly, the Oversight Act to make allowance for the funding of the OIGI from an independent source, not aligned to the SSA or any other intelligence service.
Now, is this the first time that these issues have been canvassed or deliberated on?
Not really. In fact, Chairperson, I think you'll be surprised to hear that the high-level review on panel just quoted those recommendations which were made by the two panels that were established. Can I go through them? The first one is in 2006. Now I
Yes,
can see where they are.
To assist you, we've extracted a summary. It's in a declassified document which deals with the two reports, the 2006 report and the Matthews report. If I may, Chair, these do have reference numbers. They're in another file.
Registrar, please.
But for the sake of convenience, we've extracted them now.
Yeah.
For the record, however, Chair, they're in bundle YY2 at page 32.31 to 32.40. And we'll refer to those page numbers. If we could go, please, to page 32.136.
Yes.
You will see there paragraph 13.3.2. This document deals with the Inspector General for Intelligence, and it's an extract from the report of the high-level review panel on the SSA. It reads, the recent controversy between the IGI and the former DG of SSA around the withdrawal of the IGI security clearance has raised once more an issue that has been on the intelligence community's agenda for some years, the issue of the independence of the office of the IGI from one of the entities that it oversees. Now, we'll deal with that issue in due course.
Yes.
It goes on to say, the 2006 report of the task team on the review of intelligence-related legislation, regulation and policies had this to say on the matter. And if you go over the page, it reads, while this may be administratively convenient from the point of view of the need for actual and perceived independence, this arrangement is untenable. It is therefore important to provide the OIGI with an organizational status that gives its head accounting officer status and allows it to receive and manage its budget independently of the NIA. That's the precursor to the SSA. You see that?
I see that. I confirm that, Chairperson.
And then it refers to the 2008 Matthews Commission report, which agreed with the findings of the 2006 report. And I quote, the task team recommended that the OIGI be given independent organizational status, allowing it to receive and manage its budget independently of the NIA, and affording the Inspector General full control over the resources and activities of the office. The OIGI could be established as either a government agency or a Schedule 3 organization in terms of the Public Service Act. The Inspector General would remain functionally accountable to the JSCI, but would be financially and administratively accountable to the Minister for Intelligence Services for the purposes of the Public Finance Management Act. And then it concludes in that regard to say, and I quote, we agree that the OIGI should have independent status. The process of establishing this status was underway in August 2008. And then the report of the high-level review panel concludes, having quoted the 2006 panel and the Matthews Commission, concludes, in fact, the process to establish this status has never happened, or at least was put aside with a change in intelligence management in 2009. And then 2 paragraphs down, it says, according to the then SSA Director General Arthur Fraser, there had been no surveillance of the IGI. He was spotted meeting opposition parties. He said the IGI report on PAN was leaked to the Daily Maverick. He claimed that it was the current minister who instructed him to withdraw the IGI security clearance. Now, I just mention that part now because that foreshadows evidence that you're going to give in due course.
Yeah.
But let's leave that aside at the moment. That appears to have been some of the focus of the high-level review panel. But the recommendations of the 2006 panel and the Matthews Commission in 2008, have they ever been implemented?
They've never been implemented, Chairperson. I think I need to mention that there is a letter in my possession which showed that during the tenure of Minister Castrals, that letter was written to the then Minister of Public Service, the former Minister Geraldine Fraser-Moleketi. And in principle, she responded saying that, yes, of course, the request made by Minister Castrals makes sense. Okay. So she wanted to establish a work stream, they called, that was going to deal with the whole process and take it further. But then it died a natural death.
While we're here, its relevance will become clear later. In relation to the withdrawal of your security clearance, the conclusion of the panel, that's a high-level review panel, is, or the non-conclusion, is on page 032.138. The last sentence of the first paragraph reads, the panel was not able to ascertain whether Fraser's withdrawal of the IGI security clearance was an attempt to obstruct the IGI's investigation of himself, that is, the investigation of Arthur Fraser. But we'll get to that evidence in due course. I just want to highlight it here so that when we refer to that matter, we know what the high-level review panel said or didn't say about that issue. But further down that page, that's 032138, they summarize, that is, the high-level review panel summarizes the 2006 task team report, and they're there under 5 bullets. The first bullet is important, and I'm not going to read them all. The task team agrees that the Office of the Inspector General for Intelligence should be given independent status, allowing the Inspector General to have full control over the resources and activities of the OIGI. That was the finding, and am I correct when you stated earlier this is one of the findings that has not been implemented?
It has not been implemented, and maybe I should remark here before it slips my mind to say that this is a document which was declassified by the President, and it was then made a public, it was then turned into, I don't know if to call it an instruction. So the high level, the HRP report, this one here, can no longer be seen as mere recommendations, because the President then says, get a team together and implement these recommendations as they are. But yes, of course, all those recommendations are not yet implemented 2 years down the line.
Yes, and in relation to the original report, 15 years down the line.
Yes, but Chairperson, may I please also mention this, and you'll bear with me.
Sure.
I know that I could be
No, it's
confusing your
the
evidence,
chair that
and
needs to
you are
be
supposed
with
to
you.
be
I have no
leading
power
me.
in that regard.
All right, thank you very much. And the recommendation of the President in terms of the Constitution could have a binding effect and become enforceable, even if it is a policy. And that is in terms of Section 85, subsection 2, I think it's B, which says that the top part will say that the President may develop a national policy in conjunction with the members of his cabinet. But subparagraph B talks something about the enforceability of such a policy. Maybe that could really assist our position in terms of the mess as well. But I do not want to take it further than that.
Right. And then certainly in respect of the Matthews Commission report, that finding that we've just quoted was endorsed. Although the high-level review panel shows in what respects the two reports differed, that finding that the Inspector General's office should be given independent status is common to both reports. Am I correct?
Actually, 3, not even both. The 2006, 2008, as well as the HLRP.
HLRP. Well, what is said on page, because I think as I read the report of the high-level review panel, they were somewhat equivocal on the findings of the two previous panels. But I don't want to debate those. They're here in black and white. But they do make the point on page 032139 of YY2 that over a decade, and I quote, over a decade has passed since these two sets of...
I'm sorry, Chairperson, I didn't get the paragraph there.
It's the first paragraph on page 032139 of the document of the high-level review panel that I've just put in front of you. So you go to page 32139. At the top of the page it reads, over a decade has passed since these two sets of findings on the OIGI were made by ministerial appointed entities. It appears to the panel that with the change in administration in 2009, there was no follow-up on these recommendations. The panel understands, however, that there has been an attempt to draft and promulgate the regulations governing the OIGI. These were drafted in 2010 and submitted to the then Minister Cwele and the JSCI, but it was decided to put these on hold until the promulgation of the GILAA, the act which amended all related intelligence legislation to provide for the establishment of the SSA. Is that correct?
Yes, I can see that.
Yes. And of course, and in any event, we know that even since then, the independence of the OIGI hasn't been secured as recommended by those, well, 2 or 3
Yes.
entities.
I agree with that statement, and maybe one need to also remark that the institutions of government are destroyed by the government. I don't know if it's herself or itself. But you've got this very, very, very good concept of how oversight should be conducted and so forth. But then you frustrate this organization. Even before my arrival, I like this report because it takes it back before my arrival. So you can see that my predecessors were also contending with the same issues. And it brings you to your knees, to be honest. I mean, if you're not given the money and so forth, you come there, you are excited, you say, I'm going to serve the country, I'm going to assist them. But, Chairperson, I'm there for 4 years, and I don't think that I'm going to wait any day longer when this term comes to an end. I'm just trying to survive, because you come there with your skills, and what happens? I mean, you can see that my predecessors, including myself, have failed to turn around this oversight structure. That's how frustrating it is.
All right. We could go a little further and deal with the high-level review panel report under this head. In the second paragraph on page 32-139, the panel, that's the high-level review panel report, reads, one of the key concerns of the panel is the long periods of time that the IGI post has been vacant. And then it specifies what you've already told the chair, but it was a concern expressed by the panel.
Yes, that's correct. It was expressed by the panel.
Then the penultimate paragraph on that page foreshadows a question that you will deal with in due course. And I'm going to read it to you. A question, or read it onto the record, a question of concern to the panel was to what extent the OIGI had played a role in identifying and curbing the abuses that had occurred in recent years in the SSA. Of course, the fact that the post was vacant for 2 years at a crucial time did not help. However, the panel did have sight of a number of IGI reports on abuses, such as the report on the principal agent network and others which indeed identify problems and recommend corrective action. But as far as the panel could ascertain, no action or consequent management took place in response to the IGI's reports. This raises the question as to whether the services should be obliged to act on the findings and recommendations of the IGI, similar to the status of the recommendations of the public protector. This would need further thought. What is important about this paragraph is it does seek to explain the question that may legitimately be asked, where was the IGI? And of course, the answer to that question may well lie in the certificates you referred to earlier, you recall, and the various reports. Would you like to expand on that paragraph, please?
Thank you very much, Chairperson. If I started earlier, I was just going to say that no one in the intelligence where I play an oversight role should come and mislead you by saying that we are not aware. The certificates are comprehensive documents which deals with even a transaction worth about 60 rand or 70 if it did not happen in accordance with our prescripts. So I do that. So I would have included that. I would have included all the information. And this is how the certificates travels. I sent first to all 3 ministers, and I solicit inputs. Obviously, those inputs are also not even legislated, but it's a novel thing that I introduced when I got there. But they've got an opportunity to convince me otherwise. So I will then incorporate those that I think that they have a point, and then I will finalize the certificate, and then I will send to the ministers again. We've been doing it religiously. We've got records of that. We've got covering letters, and then I will go and present to the committee as well, religiously doing that. So no one should ever claim that we are not aware. And I think that the high-level panel is also confirming that, saying that although they say that they lack independence, but we've seen their reports, and those reports are instrumental in using them to curb the abuses, because oversight should not replace the internal controls. I cannot run the SSA. I cannot run crime intelligence. What I can do is to point them to this malfeasance as well as, loopholes in the internal controls. And what I'm responsible to oversee is as to whether they develop internal controls and whether they implement them. And I think Auditor General will also be doing the same principle, follow the same principle, to say that there is a problem here, deal with it, whether you charge a person or whatever. So that's what the HLRP chairperson is also confirming, to say that, but there are reports there which are comprehensive enough.
Now, obviously, what you have just said definitely relates to the period that you have been there. So I want to ask the question whether, because you may have access to previous annual reports or certificates that were even issued by your predecessors and those before them, whether you know that those reports were given in the same way as you have been doing them, namely every year, if that is a position, and they were given to the same people and bodies.
I have that evidence to
Yes.
show that there's continuity in that office. There's continuity
Yes.
because the rest of the staff members are appointed permanently.
Yeah.
So when I got into that office, there was something that they did in 2016, 2015, 2016 financial year, and even before that, I've had an opportunity to also engage with those certificates, when I was trying to acclimatize myself with that office. Very much comprehensive, hard-hitting, showing exactly where the problems are.
Well, it's the fact that you say you have given reports. Reports have been given even before your time, annually, pointing out abuses and problems that should have been fixed, but it seems nothing was fixed in terms of what was pointed out, or maybe very little was fixed, is concerning, because the evidence I've had seems to suggest also that talking about Parliament, it would have been given the Auditor General's reports about various government departments and about SOEs, and yet in terms of how it used those reports in respect of the SOEs, about which I've had a lot of evidence of corruption, you're not sure what happens. But apart from that, boards of SOEs as well as cabinet, or at least ministers responsible for certain SOEs, about whom I've had a lot of corruption going, spreading over a number of years. One thinks that they would have been given reports every year of the state of affairs in those SOEs. But when I hear the evidence that I've been hearing in terms of what happened over a number of years, it's like nobody bothers to read those reports. And the problems continue. I mean, I was hearing evidence from the former CEO of PRASA today. With regard to PRASA, I've had evidence where the late Auditor General pointed out how irregular expenditure was going up astronomically every year, and it looked like nobody was doing anything about it. So maybe there's a problem in South Africa that people don't read reports and act on them because the kinds of abuses that I've heard about in regard to SSA don't suggest that anybody was aware of the problems, because anybody who was aware of those problems and didn't do anything really needs to relook at themselves.
I know where the problem is, Chairperson, if you allow me.
Yes, yes.
And
Tell me.
it's something which is not insurmountable. It is because you've got a body such as ours, and you only give them the power of recommendation. We have a position, and I was thinking that maybe that could be like a legacy project, something that I could do. To take myself to court and argue that I don't think that recommendations can just be ignored. I know that the argument is going to be that they are not remedial measures, but I don't think that any government in its right mind will throw money into this particular organization, and this organization only keeps on doing recommendations which are ignored, at such a huge pace, and nothing happens. So there is no power of recourse, because I always keep evidence that I would have elevated this matter to the next level, whether it's a committee. Most of the times, I sometimes even go to the president. I've gone to the previous president, I've gone to the current president, and made them aware of things that are happening in intelligence services. So this thing of recommendation versus remedial measures, I think that it's creating serious problems.
So when you say you went to the previous president, Mr. Jacob Zuma, and you have been to the current president to tell them about the problems, one, are you talking about the problems which are highlighted in your annual reports?
Yes, it will be
more,
those.
and maybe and
Yes,
more, but
yes.
certainly those.
Yeah.
Yes. And when you do that, would you bring the reports with you or not really?
Yeah, I'll
give
make a
them-
presentation, Chairperson.
You would make a presentation,
A presentation.
which is based on your annual reports.
Yeah, yeah.
And do you do that yearly, going to the president, or it's an ad hoc arrangement?
It is an ad hoc arrangement because the legislation does not put him in the scheme of things
Yes,
as certificates are concerned. It says I shall send to the ministers who shall cause them to be sent to the Joint Standing Committee on Intelligence.
Yes.
But if you look at the definition of a minister, Advocate Pretorius, on the
In the oversight.
Oversight Act, it says the minister shall refer to state president or any other member of cabinet appointed in terms of, I think, section 189 and so
Okay.
forth. So it's an ad hoc thing, in fact, that will be my answer. I've done it once, unfortunately,
Yes.
with the current president, and only once with the former president as well.
Yes, yes. Okay. But the joint committee on intelligence in Parliament, do you know what it does with these reports that you give them annually?
What I was
Do you
informed
know
is
whether
that...
it takes any action? I know that some of the things, or maybe everything that it deliberates on is not something one can talk about, but to your knowledge, does it take any action to deal with the problems?
Not the previous committee, and with the current committee, Chairperson, I'll be honest with you, the time that I've worked with them is not sufficient for me
For you to
to
pass
create a
judgment.
pattern or to
Yeah.
make an opinion.
Yes.
To be honest, they seem very much eager,
Yeah.
to follow these things. I've never ever had a member of parliament telling me to slow down a little bit because the environment is too complex.
Yeah.
And it's an environment where you deal with different pieces of legislation and so forth. So I'll not be able, but the previous one, I don't remember really anything significant that they would have done to assist. But I keep on elevating to them and making them aware of these challenges.
Okay, all right. Well, I see we are at 8:15. We were supposed to talk at 8 o'clock about whether we go further or not. From your side, Mr. Pretorius, you would still be fine to go up to 9 or?
Well, if you're asking my opinion, I'll be honest, Chair.
You are obliged to be honest.
Or I won't be deferential this time, let me put it that way.
So you'd like to stop now or
Well,
at
there
8:30?
are just one or two issues I would like to deal with that shouldn't take very long.
Yeah.
And then my view, but I'm subject to your direction, Chair.
Yeah.
I'm capable of going till 9.
Okay, all right. I was going to be very much guided by how the staff and the technicians feel, but I think because you are the only one standing in the room when you indicate as you do, I should allow that but maybe if you do what you think you.
If I could just close off, Chair, I think that last consideration is perhaps decisive.
Okay, all right. Well, I told you, you must have heard me
Yeah, I did,
earlier on say, but maybe the staff said, hey, he's abusing us.
Yes,
Yeah, okay, all right. But they are very committed. Okay, I think let's round off. My concern was simply that I was hoping that we would do enough to give us the comfort that tomorrow we should be able to finish with this evidence. But the other considerations are important. So let's wrap up and then we'll see tomorrow.
Yes. The document, which is the extract from the high-level review panel at page YY2 32.139, does mention in the paragraph we've just referred to the status of the findings. And the panel says in the last sentence, this raises the question as to whether the services should be obliged to act on the findings and recommendations of the IGI, similar to the status of the recommendations of the Public Protector. This would need further thought, and it's perhaps something that the Chair will consider, and you've given your view in that regard. But also in that paragraph, in line 5, mention is made of the fact that the panel did have sight of a number of IGI reports on abuses, such as the report on the principal agent network. Did you or your predecessor, or one of your predecessors, produce an IGI report on the principal agent network, as opposed to the internal report of the SSA? That is correct.
That is correct. It
Yes.
was a
Just
minister.
remember to articulate your answer, because when you nod, that's not recorded.
Oh, all right,
Yeah.
Chairperson. Sorry about that.
So there would have been an internal PAN report, and there would have been an IGI report on PAN, the principal agent network. Am I correct?
That is correct, Chairperson.
Right. Now, that report, have you seen that report?
Yes, I've seen that report.
Right. And it would be within your province to give it to the chair or not?
Yes, yes, we are the one who produced that report.
Yes.
Yeah.
Now, what I wanted to ask, to whom would such a report go in the ordinary course?
Yeah, and
Do you know to whom the report went?
No, I know where it went. I've done a lot of work on that. I was briefed fully on that because
Right.
it was
To whom
very
did
much
it go?
important. Yes, but this is how it started. How it started is very important. It was a ministerial task in terms of the Oversight Act. Now, Minister Siyabonga Cwele, after the SSA had concluded its own report, and they went to the then Minister of Justice, and the Minister of Justice said, "Oh, there is a lot of criminality in this particular report. Please send it to the SIU at that particular point." And I think the Hawks, if I'm not mistaken, it could have been Scorpions, I'm not sure. But then he wrote a letter to the OIGI giving them terms of reference. So he wanted them to investigate some other things. So the PEN report, which belongs or which was produced by the OIGI, will be confined to specific issues which were in the terms of reference. That is the reason why, because the Act then forces the IGI to report back to the tasking authority. If it's a president, you go back. If it's a minister, you go back. So there were several presentations that were made to all the ministers, to several ministers.
Several ministers. Can you recall which ministers?
It will be, it will have been presented to Minister Siyabonga Cwele, but when Minister Mahlobo came, it was presented to him. The information that was given to me during briefing is that it was done twice, but the documentary proof that I have is that it was only done once. So I will have like a presentation with the date, but I also have an official in the office who says that I was part and parcel of that, and I don't even have a problem to come up with an affidavit to confirm that it was presented.
Well, perhaps you could help us in that regard. Would the former president have been briefed?
Yes, I really have to check that, Chairperson.
All right, don't
I
give
really
an
have to
answer
check
that you
Yes.
can't
I have to check.
substantiate later.
Yeah.
Then just finally, in relation to this document, at the bottom of the page, the high-level review panel state, the IGI noted that there were a series of legacy issues from previous certifications that remained unaddressed. These included the following, and the first bullet reads, the involvement of the Minister of State Security in operational work and administrative decision-making of the SSA. Over the page.
I'm sorry, before you go over the page, Dr. Dintwe, do you know which Minister of State Security they are referring to?
It's Minister David Mahlobo.
Okay.
And then halfway down, there are a number of bullets. I'm not going to read them all. Halfway down, there's a bullet which reads, there is a culture of non-accountability in the SSA. Was that a concern that you know was addressed to the high-level review panel?
That's correct, yes. It was our concern.
Right. And then at the bottom of that paragraph, this long list of issues that remained unaddressed includes many of the issues identified by the panel and suggests that the IGI was not being taken seriously by the SSA. Is that a view that you share or disagree with?
It is a view that I share, that the office was never, and even now, taken seriously. And Chairperson, these are the issues that I'm comfortable addressing because they belong to prior to, or they came to the fore prior to my tenure. And it will be reports that I received and so forth. But again, even evidence which just shows that we have since told you that ministers, for instance, should not involve themselves in operational matters, but you will have incidents where the minister would have, was involved in those issues. So those are the issues that I base on what was given to me during the briefings, but it also materialized under my own tenure.
Chair, then finally our team has produced a document on the status and source of the document, the minimum information security standards. The source is the Public Service Regulations, published or promulgated in terms of the Public Services Act of 1994. Chapter 5 of those regulations deals with electronic government regulations. Part 2 of Chapter 5 deals with information security, and Part B of Part 2 deals with the minimum information security standards, and there's a section which obliges the Minister, in consultation with the Minister of Intelligence, to issue minimum information security standards for the public service in the form of a handbook, and that was adopted by Cabinet on 4 December 1996. So in summary, it's a standard for minimum information security measures that any institution must put in place for sensitive or classified information in order to protect national security, and its source is in regulation and is therefore binding. Chair, if I can just hand that up, we will include it in the budget.
Yes. Yes, no, that's fine. And then the miss itself, if one could get, I don't know whether there are different misses or this document based on what Mr. Pretorius has just read there. It reads like different ministers can produce different documents of this nature under their departments.
No, there is a base document.
Yes, which applies to.
Yes, which applies to all government
We will
departments.
provide it, Chair.
Which happen to deal with information of
Yes,
which is sensitive
yes.
in nature. Yes.
How thick is that document?
It's very short. I remember that it runs up to about paragraph 46 or so. It's not a thick document.
Yes.
Yeah, at least by my standards. It's
We'll
about
provide it and put it in the
10,
budget,
15.
Chair. It's
Yes.
available on the internet.
Okay, all right. Okay. Was that your last?
Yes, Chair. Thank you.
Okay, thank you very much. We are going to end here for the day. The arrangement, of course, as I understand it, is that you will come back tomorrow evening, Dr. Tintwe,
That's correct, Chair.
to be here at 4 o'clock, but accepting that we might only be able to start at 5. But if we are able to start at 4, then that would be.
Chair, I'm informed that the MIS document is in the legal framework document which you have. It's at tab 3.
Oh, okay. Thank you. Okay, we are going to then adjourn. Thank you to everybody. Thank you to the staff and the technicians and everybody. Thank you to you, Dr. Jintwe. Thank you, Mr. Pretorius and your team and the investigators for making it possible for the commission to sit until this time. Mr. Pretorius, if I could see you in chambers briefly after just adjourn. We adjourn.